CH-1.
ಸೊ ನಾವು 24ಕ್ಕೆ ಮೈಸೂರು ಹೋಗೋದಂತಿತ್ತು. ಇದಕ್ಕೋಸ್ಕರ ನಾವು ಒಂದು ರಿಸೆಪ್ಷನ್ ಅಟೆಂಡ್ ಮಾಡಿ 25ಕ್ಕೆ ಹೋಗೋಣ ಅಂತ ಅನ್ಕೊಂಡಿದೀವಿ. ಬಿಗ್ ರೂಟಕ್ಕೂ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ.
ಮ್ಯೂಟ್ ಮಾಡಿ.
Matter has been approached. We had filed one writ petition, my lords. We had withdrawn it with the liberty to approach the Honorable Supreme Court. The Honorable Supreme Court has given us direction to restore file an application for restoration of this writ petition, my lords. This writ petition was filed challenging the contracts entered by UIDAI with the
Supreme Court has said that file restoration application.
Yes, my lord.
Even otherwise you can file.
I have filed that it's restoration
Well,
application.
you want to post it?
Yes, my lord. Tomorrow.
Get it tomorrow. Why tomorrow?
My lords, it's national security, my lords, because almost 100 crore people's data has been entrusted to.
Today is what? 23rd?
Yes.
23rd.
Let's make a submission with respect to serial number 11 minutes.
One by one. Yes, ma'am.
With kindly, my lord. The serial number 59, contempt.
59.
59. The same subject matter, company has filed a writ appeal. My lord, that is notice is ordered by this 9/9. Your lordship has given date. So it may be connected to that writ appeal. Both the case can be heard on merits, my lord.
So give the number of writ appeal.
It's
To be listed is 59. To be
9/9,
listed
my
with-
lord.
To be listed with writ appeal number so and so arising from the same order. On which date?
9/9.
9/9, as requested by learned counsel. For learned counsel, Mr. Subramanian, but
I will inform, my lord.
you are for your
I am for accused.
as requested by learned counsel for the respondent. Yes. Yes, please.
Madam, contempt, madam. Fresh matter contempt, madam.
Pardon?
Filing fresh matter, madam.
Fine, it will be listed. No urgency. No memo.
Well, it's serial number.
Pardon? 30, yes. Contempt, what is, why a rejoinder in contempt matter? Replies filed. Let it be called out. At that time, we'll consider your request.
Let's serial number 11. I
11.
believe the appellant has already implemented the learned single judge's order. If some time could be given, my lords, I'm told that they're continuing to take further actions in the matter. The matter.
What is that matter?
This is with respect to appointment of teachers to aided institutions, my lords. So the order of the learned single judge says that till 2024 appointments are to be made. There is an order that has been recently passed on 7/8, granting permission till 2020. I am told by the learned
Recruitment.
recruitment, my lords.
So it is implemented.
It has been implemented till the year 2020. Insofar as the other 3 years are concerned, I'm told by the learned advocate for
Lord,
the
the
appellant.
implementation was only till 31/12/2015, which they had sought for, but we have implemented it till 2020. Now, my lord, I'm making an attempt to see that, my lord, for the next 3 years also, if they could, my lord, implement it.
So you on time. At the
Please.
joint request of learned
Please.
party, stand out
I'm for the
11.
respondent.
11th of September.
Very well.
My lords, kindly.
Serial number 89, my lords. Serial number 89, serial is not keeping well, my lords. It's running from high temperature. A week's time may be granted.
For respond number
Serial
7
number
and 8.
89. I will inform the other side also.
For respond number 7 and 8.
So what do you want?
2 weeks' time may be granted.
19 matter.
No, my lords, at least a week's time may be. He's not keeping well. He's running temperature for that.
Not keeping well.
Yes, my lords.
Who is there?
Senior counsel SN
Since
Ashok.
it was submitted,
He
that
has
the
already-
counsel who is to
A date
appear on
may be
behalf of the
filed.
petitioner is in indisposed health, so must stand over to 11th September.
My lord, serial number 12, my lords. My lords, serial number 12, my lords. My lords,
Yes.
My lord, education matter, my lord. Lord, connected matters, my lord, already, my lord, posted in second list, my lord.
Which,
What at
which matter?
education matter, my lord.
Education.
My lord, I'm moving for the end of the list. The urgency is this, my lord, I'm challenging the learned single judge's order, where management quota seats have been, my lord, ordered to be released in favor of government. my lord, all the connected matters, my lord, are
That
listed.
you mentioned earlier, this matter.
Please, my lord, that is posted along in second list, my lord. Two matters are missed out.
Today it is posted.
Today it is posted, my lord. In second list, all other matters are
This
posted.
will come tomorrow then.
Today.
Wait the outcome of the today's matter, then we'll consider. Not, it can't be posted today.
My lord, serial number 70, my lord. Can I
Because it's a
intervene?
second list 2 to 9.
Serial number 70.
Let that matter be called out and considered, then we'll consider this request.
My lord, serial number 70, 70. My
Yes,
lord, the office objections has to be complied by filing a detailed affidavit. Can I seek 1 week time, my lord?
all right, 12th of September.
My lord, serial number 12, my lords.
Till 12.
2 days time may be granted, my lord. Senior counsel he is not keeping well, my lords.
September.
My lords, kindly. Serial number 76. Serial number 76, my lords.
Yes.
Serial number 76, I'm sorry. My lords, it matter was heard on 30/10/2023 and the additional affidavit was directed to be filed. But it's coming in the office objection list, my lords. It's not getting listed. It's not reaching. 76, my lords. Office objection, this court said let the government file additional affidavit. Officers, principal secretary, they filed additional affidavit. Matter has to come in admission list, my lords, 76. Because it is for office objection along with counsel submission, it's getting listed in office objection list, my lords. Any day in convenient to the court, the matter should.
76 CCA 224/23 may be listed on board for the purpose of admission hearing, with an observation that all office objections shall be considered at the time of hearing.
Please.
Kind indulgence, my lord. My lords,
Any date, my lords. Any date in 76. Any date convenient. 76, my lords. 76. Any date.
76, we are directed to post it on admission.
Please, my lords, please.
Subject to all office objections.
I will make counsel submissions.
To be considered at the time of hearing.
Please, my lords. Please.
Yes.
kind indulgence, my lord. My lords.
Yes.
My lord, this is regarding the serial number 52 to 59 of 23. So, my lord, I'm unable to make my submissions because I have been served substandard unreadable document. I have brought to the notice of the court officers also, and on their advice, I have thrice sent the email, text, and personally on 22nd July, I have requested the senior counsel to serve me a readable copy. This is the document they are submitting, sir. I'm unable to make my submissions and do the proceedings. Pardon, sir?
Who is appearing?
Pardon, Your Honor?
Who appears, who has given this copy?
Mr. Rajshekhar, Government Counsel.
Request him to give us a better copy.
I have requested personally. I have sent 3 emails, reminders, text.
Today it is listed.
It is listed, my lord.
Let us see when it comes, we'll tell you.
Your Honor, I request the Honorable Court to give me some time also, because on the date of the hearing only, they are serving me for past 2 years now, which has directly affected my case, and this will only raise the reason of reopening my contempt petition.
We'll convey to the council to supply with the better copy.
And I also request my lord to kindly give me a date on November 1st week, because my university exams are going back to back.
So you want time, learned party in person?
Yes, Your Honor.
Miss MS Sri Rupa Roy, Perez for time. Stand over to which date?
November 1st week, kindly, Your Honor.
First week of November.
Also, Your Honor, my matter has been challenged in Supreme Court. So.
7th November.
Yes, Your Honor.
We further request that certain annexes to the reply are not legible. It will be open for the party in person to request the counsel appearing to the respondent to supply legible copy, who in turn shall supply such copy to party in person.
My lord, kind indulgence, my lord. Serial number 64 in this matter, my lord. Similar
may supply fresh copy, fresh and legible copy of the reply and the annexes. Of the reply and the annexes.
Kindly notice, my lord. Serial number 64 in this matter, my lord. Similar matter which pertains to forest lands, which is also yet to be listed, my lord. It may be tagged along with and here once for all, my lord. It will be in 22nd or 23rd, my lord. We have sought for interim order to immediate vacate and hand over the forest lands in question.
64.
64, my
It
lord.
is PIL. Let it be considered independent.
Grateful, my lord. Grateful.
That time we'll see.
Yeah, grateful, my lord.
Tomorrow, my lords. Not at the end of the lease, my lords, tomorrow it may be taken.
Which one? Tomorrow.
That education matter.
Tomorrow.
Please.
So list number 2, Sasi number 1, Kavita Damodaran.
Here on behalf of the petitioner. Petitioner is a 12th standard student for CET counseling. She is eligible for sports quota, but the KEA, the respondent number 1, is not acknowledging that. I don't see.
But you are considered in which category?
Pardon me? I'm otherwise in general category.
No, that reference P5.
Pardon my lord?
Reference is given in terms.
Preference is given for sports quota, that my lord will see the
P1, P2, P3.
No, not like that, my lord. Participation in national games. At ink page 38 is the policy of the KE of the state. Ink page 38. Rule 9 was amended.
Where is rule
Page
9?
38.
Page 30. Rule
38.
9. Yes.
Rule 9. That clause 2B, my lord, if I'm allowed to read that. Following candidates shall be eligible for selection under sports category, namely candidates who have represented the state and country and won medals or participated in sports competitions during the last 3 financial years, including the financial year in which the candidate has applied the application for CET under sports quota. So even participation in national games.
So B1 is applicable.
B1 is applicable, or 2 or best, 2A also. The selection of candidates under sports quota shall be as follows. 2 best or 2 highest achievements in sports competition during the year specified in clause 1 shall be taken into consideration. However, only 1 best or highest achievement year shall be considered in a financial year. Well, at ink page 41, the categorization is given. According to this rule, what are the various categories? Ink page 41, my lord. Pursuant to the amended rule 9, the various categories I have set out. From 47 onwards, gold medal in Olympics, silver medal, etc., gold medal in Asian Games. I come in entry 88 at ink page 50. Entry 88 at page 50. Entry 88 at page 50, my lord, is participation in Khelo India Games or school games. That is at national level. Entry 88. And the certificate issuing authority is the Government of India, SAI, or the National Sports Federation.
National level.
Yes, national level. That certificate, my lord, you'll see at the next page itself, page 51.
So participation is enough or medal is required?
No, participation is enough. Rule 9(1)(b)(1) talks of participation.
And who is selected in your place? Nobody.
No, nobody is selected in my place.
Notice returnable on.
But the counseling will end day after tomorrow.
Counseling is ending day after.
Day after tomorrow, ending.
Tomorrow, notice returnable tomorrow.
Grateful.
Summons by hand delivery is permitted.
Hand delivery.
Today.
Grateful. Great.
We just take instant. Third learned senior counselor. What is it? Office is a responsible. Start. Officers may be removed within 1 week, then heard so and so.
This is number 2. So Suraj Nayak.
Appear in serial number 8, which is connected, my lords. 2 to 9 are a connected batch.
2 to 9 are same.
2 to 9, my lords. Serial number 2. There is extreme urgency. There's a direction of the learned single judge to give up certain seats to the private colleges. Counseling commencing, the entire seat matrix will get affected.
This is appeal by state.
No, my lord, this is an appeal by the colleges.
College.
But if you want to make your request, you make it.
What is the order first?
Lords, the order is at page 24. Interestingly, it was, my lords, 14 students in my case. If your lordships please take the appeal in serial number 8.
So you are arguing number 8.
8, my lords.
Judgment is not common.
Similar orders, my lords, but not a common judgment.
Verbatim similar.
Except the numbers will vary. The number of seats to be given.
But verbatim. No, reasoning also same. Everything.
Page 24, my lords, in the appeal. 13 students, my lords, filed a writ petition seeking a direction, my lords, to the respondent university therein to issue the hall tickets and permit them to take the MBBS examinations. Now, a brief background before I take your lordships to the order. The consensual agreement, my lords, which is executed between the state of Karnataka and the colleges pursuant to, my lords, the Karnataka Professional Educational Institutions Act of 2006, was entered into in 2018. These admissions were made pursuant to that agreement. Students have been with the college, my lord, since 2018. They have written one set of examinations. In their second year, my lords, the hall ticket was withheld. They moved this honorable court. In the writ petition of the students, the learned single judge, my lords, the operative portion, if your lordships please come to, at page 34, issues the following directions. Para 12. Having taken cognizance of these irregularities in the admission process by the medical college, the following observations are made by this court. To rectify the violations and ensure the integrity of the admission system, the approval of admission of petitioners will be subject to the R4 Medical College, that is me, my lords, surrendering and transferring 7 seats from the management NRI quota out of 20% to the state merit quota for the upcoming academic year. This transfer should be completed in compliance with the guidelines set forth by the KEA. The college shall give an undertaking that it will ensure transparency and fairness in admission process and that all admissions will be strictly based on merit, and the college will never indulge in attempting to block or manipulate seats. The college is hereby cautioned to strictly adhere to the regulations and directives issued by the NMC and the KEA in future admissions to avoid recurrence of such violations. Failure to comply with the above directives shall attract stringent directives, including further reduction in seats and other punitive actions. The respondent for college is imposed with exemplary costs of 8 lakhs for having manipulated the admission process by blocking seats. Colleges have blatantly violated the regulations and are litigating through the students. Costs of 8 lakhs shall be paid to the state.
Direction number 2 is given under some provision.
Direction 2, my lords.
To surrender the seat.
No. It's a...
Now it refers to transfer should be completed in compliance with the guidelines of KEA.
That is the transfer, my lord. This is a 226 direction issued by the...
It's a pure 226.
226. And in the writ petition of the students. Is that right? Where's the act? Please sit down. Prayer, my lords, your lordships get in para 1 of the order itself at page 28. Petitioners who are the students of R4 college, I am the college, my lords, have assailed the action of the respondent university concerning non-issuance of hall tickets permitting petitioners to take the MBBS exam on the ground that the petitioner's admission is not approved by the competent authority. I have, as a college, my lords, admitted the students pursuant to clause 5D of the consensual agreement. That agreement is with the state government. It is executed under the 2006 Act, which I will place, which has a non-obstante clause that the agreement shall prevail over all else and that the Act shall have overriding effect. These admissions were never disturbed or cancelled, my lords, by the NMC or any other authority. Students have been in the college, my lords, since the admission took place, in my case, since, my lords, September 2018. In a writ petition filed in 2021 by the students, the NMC tells the learned single judge that the admissions are illegal. And the students, my lords, continue to remain with the college. And basis that statement of the NMC, my lord, this sort of an extraordinary order is passed, asking me now to surrender, my lords, the seats in the upcoming round of admissions that has to take place. Costs of 8 lakhs are imposed, and there is no finding, my lords, I can say without risk of contradiction in the order of the learned single judge as to the effect of the consensual agreement. If indeed, my lords, the admissions of these students were bad, they would have been annulled, my lords, under section 10 of the Act on the very next day. And from what I understand, my lords, in all of these appeals, a similar order is passed. There is no factual consideration or discussion. There are, my lords, some sweeping findings given that students have connived with the colleges to gain the admission. My lords, with great respect, there must be some pleading, a finding to that effect. And I, as a respondent in the students' writ petition, I'm now, my lords, foisted with these conditions. And for a moment, my lords, have a look at the Act. It's not that I have acted, my lords, in a vacuum in some. It says the material on record depicts a very sorry state. That, my lords, with great respect, there's nothing. That finding should have been in the order.
But there were no objections filed by the state, by the Director of Medical Education, nor by the KE. So, my lords, where is the material is the question I asked myself. There was no material placed on record other than in one case. In fact, there are about 8 cases listed today. In one of the writ petitions, the National Medical Council files objections without any material to say that there is seat blocking. I'm subject to correction. I don't think in Dr. Sondhi's case or my case was there.
For a similar college.
Similar college, my lords. The only difference was that I also espoused the cause of my students. So I was arrayed as a petitioner. So I was petitioner number 1 and the students were petitioner numbers 2 to, I think, 15. That's the only difference.
Now kindly peruse the Act, my lords, pursuant to which the consensual agreement is entered into.
But then the relief is something else.
Is something else entirely. That's my first submission to your lordships.
So that main relief is not granted.
Is not granted. Their admission is made subject to the outcome. Sorry.
No, it is. The students are permitted to have the whole tickets. The prayer is granted or not?
That was issued, my lords, pursuant to an interim order of this honorable court, where in fact the authorities approved their admissions conditionally. And that your lordships find a reference to that. Is there in the order? No, interim order is not there.
What is the effect of this direction number 2?
That, my lords, now in the upcoming, my lords, admissions that are to take place, the 7 management seats that would fall to my share are to be surrendered. It's a sort of a penalty that has been imposed on me by virtue of the order of the single judge. It is not prescribed anywhere.
So the effect is not for this year, next year.
This year. It says surrendering and transferring 7 seats from the
upcoming academic year.
Upcoming academic. So the counseling is now commenced, is commencing tomorrow, I'm told. Didn't say that.
We are really staying this condition, the direction number 5 for cost.
And 2, my lords.
2, it will amount to allowing the appeal at this stage.
My lords, 2, otherwise what will happen is, then my lords, my appeal will be infructuous. The seat matrix will be issued on the basis of this
To
direction.
say it will be subject to outcome of.
Can I just suggest this, Manoj? Now, I understand your lordship's quandary here. It would amount to allowing the appeal, but I would differ only on one point. In case, my lords, my appeals were tomorrow to be dismissed, it can always be accommodated in the next year. These directions are more punitive in nature. So whether it's done this year or next year will not make a difference. So let it be stayed right now. Otherwise, the entire seat matrix will, where there's 40% for the government quota, 40% for private, and the balance 20% is, as per the consensual agreement, apportioned. Now that will do, it will do havoc to the entire seat matrix.
All those things will take care, students' interest, your interest, the other side interest, at the time of final direction.
But one undisputed position here is, my lords, I will quite see if there is some stigma in my conduct, I'm in your lordship's hands. It is undisputed that the admissions that I have made is pursuant to the consensual agreement at Annexure A. I have signed it with the state government.
Take 100%, your submissions to be 100% acceptable.
Lordships.
For the sake of considering.
Please.
But even then, if we stay this direction will amount to allowing the PT.
My lords may
It will-
state subject to further orders to be passed in the matter. Let my lords the counseling process at least
Stay
take
in the
place.
different way.
Then what happens, my lords? The seat matrix gets issued basis this direction. Then it becomes irreversible, as your lordships know. I would therefore be foisted, my lords, with this penalty of giving up these seats this year. Will be given undertaking. Want to give an undertaking?
Give an undertaking in case appeal were dismissed.
I believe 2 to 9, my lords. There are eight appeals before your
Number of
lordships.
seats to be transferred are varying in each case. Dr. Sondhi's case, I think it's 7. In my case, it's 9. All put together, I think about 212 such seats have been directed to me. All the petitions.
I make a submission, my lord. I appear for the state and the DME. As on today, my lord, the preparation of seat matrix has been kept on hold. Insofar as these colleges are concerned. Insofar as these colleges are concerned, my lord, the seat matrix preparation has been kept on hold and has not been proceeded with. They're waiting for the orders of the Honorable Court. So, in fact, if this is stayed, my lord, then the process will not go forward.
Why? That's your lordship's staying this direction does not impede the state from proceeding with the seat matrix, my lord. Don't know how my friend is saying that.
So particularly since the state did not object before the learned single judge. No objections were filed
Yes.
by all three functionaries of the state.
Since my friend is before your lordships, my lords, I'm sure he would fairly submit that the consensual agreement was with the state government. Annexure C, my lords. I'll just tell your lordships, which page is it? That is only the list, my lords. There was no endorsement issued. That, my lords, the National Medical Council said in its statement of objections. There was no endorsement issued, my lords, by the state or the KEA, subject to correction in the other cases. It is the medical council that came and said the admissions were illegal. If the admissions were illegal under section 10, on the next day, they ought to have been annulled. How is it that the students remained in my college, my lords, from 2018 onwards? They wrote 1 year's examinations. It has never been the case of the state or the KEA that there was any such illegality or violation of, my lords, the consensual agreements.
In fact, just to supplement what Dr. Sondi said, my lords, the first year examinations were permitted to be written.
That's correct. There is no endorsement.
Not served with a copy in this manner.
I think they've completed the
Yes.
course also.
My instructions are there.
Completed the MBBS course itself, all 4 years, completed the course.
They have completed. Yes. Please. What would the amount be? Difference in fees. I'm in your lordship's hands, no? What, 4 weeks? Within 3 to 4 weeks. It'll only be known after the admission. It will be in the upcoming admission.
Sorry, amount which will be collected as fees in this quota will be a matter of record with you.
Yes, my lords.
So the amount, differential amount shall be deposited within 8 weeks from the date of filling up of the seats
Please,
in the said quota.
just to show the bona fides of the appellants. Lordships may.
Full stop. This direction is without prejudice to the rights
So
and
grateful.
pretensions of the
So grateful.
appellant. And to balance the equities between the parties. As far as the stay of imposition of cost is concerned, what could be immediately noticed by the court was that the judgment and order of Learned Single Judge was passed on in April 2024. And the appellant have moved the court after delay of 4 months, which is
How much is the delay? How much is the delay?
which is an aspect could not be overlooked. Therefore, in that view, for the present, therefore the state direction is stayed to the limited extent that the cost of these 2 lakhs shall be paid out of the total directed to the Karnataka State Legal Service Authority. The rest of the amount shall be, the rest of the cost shall be subject to the final direction to be issued. by the court.
One small request.
Yes.
Would your lordships consider
Difference of fees आता है पहले. Difference of fees over and over the government quota merit.
But that difference be between the private quota, my only request, why I'm submitting this is consciously, I'm aware of the fact that the seats that were allegedly seat blocked and the seats which were given to these petitioners were private quota seats. They were never NRI or management quota seats. So in fact, my lords, one of my submissions is going to be the fact that the learned single judge directed us to transfer NRI management quota seats is grossly disproportionate to even assuming that we did indulge in seat blocking. It was for private to private. It wasn't private to NRI. It wasn't government to NRI. It was private to private. So let it be the difference between private and because the NRI management is substantially higher. So difference, I mean, the lordships are as far as difference is concerned. Let it be the difference between private and government.
This submission is common to all appeals.
Yes, my lords.
I am not yet in a position to
Lord,
confirm that.
so far as that submission is concerned, my lord,
Must tell me about your call.
In fact, we've specifically pleaded so in. No, why I'm submitting.
We are only today noticing that, noticing your submission that the surrendering direction has no factual basis. In what way it is baseless, it is for you to argue at the final hearing. So we are
My
not.
only request is because the punishment meted out to me is grossly disproportionate, even assuming I did indulge in seat blocking. At best, it could have been private quota.
That can be recorded. It was submitted that in any view, the surrendering of the seat as directed would amount to punishment and also a disproportionate punishment to the alleged irregularities.
So therefore, consequently, could it be therefore, the direction to deposit may be considered. Let it be the difference between, we to show our bona fides, the difference between government and private will deposit. The NRI management.
So we have said we are not granting stay, we have granted stay. Indirectly.
No, of course not. The only thing is the fees that we now have to deposit here could be considered, could be reduced to the difference between private and this, because even that will show our bona fides. My only, I wouldn't.
You are giving admission to the NRI quota.
No,
Then
it was not one of them, but that's what I'm submitting. The alleged seat blocking, even if assuming we did indulge in seat blocking, the petitioners who came in were not given the NRI management quota. They were given private quota. So even assuming I did indulge.
So whatever fees difference is there.
Between private and government, but again, because NRI is even higher than private. I'll explain this. As per the consensual agreement.
But the direction is to surrender from NRI.
That is factually wrong. That's possibly based on the factual premise that we gave an admission to NRI quota. We did not give it to NRI quota or management quota.
That is again fact-finding inquiry.
No, but
although maybe matter of record, then you produce all these things.
No, my only submission is in the absence of any pleadings by any of the state authorities. In fact, the state government on 2 occasions permitted us to write the exam. We were forced to approach this honorable court because at the 3rd occasion, The RGUHS wrote to the government. The government did not respond. So we were forced to file a writ.
Your lordships are doing it to test our bona fides, my lords. Once the process takes place, we will come back before your lordships. If my lords at that stage feel some modification is required, we'll be in the hands of the court. Yes, my lords, they are yet to appear. Very, very great. Yes, please.
Different, my lords. In my case, in serial number 2, it's 12 lakhs. Sure, my lords.
We'll ask my friend to make a table and give it.
Certainly, we will do so. Certainly, my lords. By
Quite,
Absolutely.
quite so. So obliged to your lordships.
Grateful.
So obliged. Great. Please, my lord, that would be okay. Grateful to you, lord.
May I request 3 more matters to be connected along with serial number 9? For the institution, I had filed 1 petition. Students, not individually, they filed 3 more petitions. Overall, not my seats are liable to be given up not because of number of petitions filed. Students are filed.
Great.
Please, madam. Any details? Clear it.
Please, my lord, we shall do.
You will submit this chart. Public.
This is list 1, content matters. Serial number 1. Mr. Ashok T.
Your lordship, the honorable learned single judge has passed an interim order, your lordship, against the respondent herein, directing him to stop the construction, your lordship. Despite an interim order, he has continued to put up the construction in the property, your lordship. He has violated the order of learned single judge, your lordship. Therefore, we have filed this petition. The order passed by the learned single judge.
Now for posting.
Yes, he has completed the construction, your lordship. Pursuant to the an interim order passed by the learned single judge, your lordship. Please, your lordship.
Succeed before learned single judge will be demolished.
Your lordship, notice may be issued to him so that let him replies.
So any replies filed in the main proceeding by them?
He has filed reply, your lordship.
So what they have said about the layout plan?
No, there is no level plan, your lordship.
Notice returnable.
Much obliged.
We'll go to 12th November, 12th September.
Please, sir.
May I please, my lords.
Serial number 2.
Serial number 2, my lords. My lords, at page number 60, my lords, High Court has observed that
2.
2, 3, and
Notice returnable.
please, my lords.
13th September.
3, 4.
3, 4, 3.
Same, my lords.
Same.
3, 4 are same, my lords.
All up to 4. 2, 3, 4 same.
This is number 5. Mr. Siddharth Padmaraj.
Kindly pass over the matter. They have engaged a senior counsel. Kindly pass over the matter.
Pass over matrimonial. This
No, madam. Content. Yes, ma'am.
matrimonial visiting rights.
Yes, ma'am.
Password.
Number 6, Mr. Narayan Bhatt.
Petitioner, my lord.
Notice,
Please, my,
18 September.
please, my.
Number 7, Arvind Jain.
18 September, notice 18 September.
Number 8,
Lord, I appear for the complainant, Lord.
number 9, Mr. Nitin Ramesh.
I'm so sorry. I appear for the complainant, Lord. It's a case of
Notice
pension.
returnable on 19 September.
Great.
Please, grateful.
Writ appeal matters. Number 10, Saurabh RK. Number 10,
My lord, could it just be passed over? The learned advocate general will be appearing in this matter.
Possession of the property has already been handed over to.
Hospital, cancer.
Yes, my lord. Setting up of a cancer hospital.
Same matter.
Construction of cancer hospital.
You are for?
I am for the corporate.
Corporate. And advocate general is for?
My lord, for the state, my lord.
State.
Yes.
Who is for appellate?
Mr. Saurabh RK.
We'll keep back.
Proceeding has affected some extent.
Let the other side come. Appellant come. Keep back. Yes.
Chamber 10, I apologize, minutes. Could it be passed over, minutes?
Take rest.
No. Could it be passed over, minutes?
Pass over.
Please, minutes.
Obliged, my lord.
11 and 12 are urgent. Number 13,
Appear for respond number 2, my lords.
Mr. TP Muttanna.
Number 13.
Number 13, Mr. TP Muttanna.
I have for respond number 2, my lords.
He is reinstated or not reinstated?
My lords,
The employee is reinstated.
lords, I am unaware, my lords. The appellant is a bank.
Appellant is the bank. So you are reinstated.
Lords, I am for the CGIT, my lords. Respond number 2.
You are,
Neither
you are no locus. Why?
None of the contesting
Really?
parties are before, my lords.
It should not be given party. The industrial court can't be a party. Yeah, next. Keep back.
Number 14, to Manivannan Ji.
For the cavator fourth respondent, I require 2 weeks time to file my counter, my lord.
That's in this matter, my lords. Interim order requires to be considered. For this reason, my lords, this appeal is with regard to the
What do
revenue
you say
entries.
about the request? What do you say about the request of the other side?
Lords, the annexure B, which is passed by the respond number 3
We
assessment
are
commissioner.
asking, what is your say about the request to adjourn the matter for 2 weeks made by the other side?
I have no objection, my lords.
Okay.
Till then, interim order of
The
stay,
request
my
of
lords.
learned advocate, so and so, the respondent wants respondents 10 to 12th of September.
Till then, interim order of stay, my lords, annexure B is required.
The mode is
Otherwise, my
operating.
lords,
Then it is to be heard, Mr.
Please.
that, my lords, before the single judge interim order of stay was there and
So if you want to
continued.
argue, then please argue. If you are ready to give adjournment to your learned friend, then we'll adjourn it. You decide for yours. We have no objection in either hearing the matter or granting adjournment. If you have any objection to adjournment, we'll hear the matter.
Then let them not precipitate the matter, my lords. Now the matter is before the respond number 3 Tahsildar.
Right.
Wherein, my lords, they moved for seeking a change of revenue entries. And therefore, my lords,
What is it about? Let us see.
with regard to the revenue entries, my lords, the respond number 3 order to change the revenue entries
in the name of respondent number 4, from the name of one Munyappa, who was admittedly a grantee with respect to the land bearing survey number 22, measuring 2 acres, subject property, my lords. The appellant claiming that he is the grandson of the grantee Munyappa, and the respondent number claiming that he is the son of the grantee, even though this the respondent number 4 in no way related to the grantee or consent to the subject property. All the way before the respondent number 3 and 2, my lords, the respondent number 4, he contended that the grant in favor of Munyappa, son of Munyappa, and however the appellant contended that the grant in favor of Munyappa, son of Chikka Kunchappa alias Munyappa. Even though the Tahsildar respondent number 3 held that both are claiming under the very same grant proceedings with respect to the subject property, but the respondent number 2 assistant commissioner deviated that opinion, stating that the claim of the appellant is different from the property claimed by the respondent number 4. And the Honorable Single Judge rejected my writ petition only on the count that, my lords, the institution of the suit was not disclosed in the writ petition. And that suit, my lords, a bare injunction suit, restraining the respondent from interfering with the appellants, the position was filed pursuant to the commencement of the proceedings before the respondent number 2 and 3, my lords. And the suit proceedings also subject matter of the land grabbing prohibition proceedings, and that order also annexed to the writ petition, and thereby, my lords, and the stay is not granted, my lord, the consequences upon that, the respondent number 4 will take the change of revenue entries. Please. Till then, at least, my lords, interim order.
I oppose
always
for
was-
any interim order.
Please. Now, before the Tahsildar respond number 3, my lords. Now, in view of the orders of the
It
LGC
is
court,
just
my
the
lords,
compliance of the order of the learned single judge. That
Not
is all.
Before the respond number 3, Tahsildar, my lords, the respond number 4 moved an application seeking for change of RTC entries based on the impugned orders, and that is pending adjudication now. Now, in view of the dismissal of the writ petition, my lords,
Two.
Please, please, please.
That is not the interim order that they have sought for, madam.
Stay was granted, now.
The Tahsildar proceedings is never, you may kindly turn to page number 212, the interim application. That is not the order which they have sought for at all. All that they are seeking is the stay of the deputy commissioner's order, which has been confirmed by the single judge. The proceedings before the Tahsildar is not mentioned in their stay application at all. My lords, granting status quo, in that case, I'll argue the matter, my lord. In that case, I'll argue the matter. Because the only grievance you may kindly turn to. No, the Tahsildar is just executing the order of the deputy commissioner. He is the executory body. He is not passing his own fresh order. What has happened is the deputy commissioner passed an order directing the deputy commissioner passed an order directing the revenue entries be changed in my name because I am the son of the grantee. That literally will amount to staying of the entire proceedings impugned below, my lord. Because the Tahsildar is just executing the order of the deputy commissioner. He is not passing any fresh order. Or one thing, my lord, my humble submission, whatever the order passed by the, or to be passed by the Tahsildar will be subject to the outcome of the writ appeal. That is all, my lord.
Please.
Rating of flood control.
R4, my lord.
Lord, I appear for respondents 1 to 3. Obliged, my lord.
This is number 15, to TH-1.
I appear for the respondents 2 and 4.
To TH-1. Number 16.
I appear for the accused in this matter, my lord. Lord, there's an endorsement issued, my lord, to the.
Mr. Swami India.
Lord, I request, my lord, may I file a 16. I file a memo, my lord, in regard, my lord, there's an endorsement issued to the contemner stating that, my lord, certain documents had to be submitted by them. But those documents have not been submitted. For that reason, my lord, it could not be complied. That reason, my lord, I'm filing a memo with the endorsement issued to the contemner. May I request, my lord.
All the documents have been submitted.
Certain documents, my lord,
January
furnished by the contemner, my lord. Now, those documents, my lord, for that reason, my lord, an endorsement is being issued. Stating for, asking for those documents, my lord. Those documents have not been furnished. I'm sorry, my lord. I'll instruct. I'll instruct. I'm sorry, my lords, but Lord, it has been. My lord, I am aware of. No, I am not, my lord. 12/5, my lord. 12/5, my lord. I have issued an endorsement, my lord. 7. Lord, 7/5/24, my lord. An endorsement is till now, my lord. Lord, may I request, my lord, it's a death certificate, family survey certificate, original birth certificate. May I produce, my lord? I have also with an endorsement, my lord. My lord, there's an endorsement issued, my lord, on 7/5/24. My lord, 7/5/24, my lord, there's a list of documents prescribed in the endorsement, my lord. The translated version of the endorsement is also produced.
It has been submitted in January 24 itself, my lord. Yes, ma'am.
Lord, if it is.
I'll produce, I'll file it. Watch. Yes, ma'am. Submitted. In January 24 itself.
Lord, this is dated 7/5/24, my lord. The second endorsement is dated 7/5/24, after.
Much.
Much. Much. I'm sorry. I'm sorry, my lords, but
This is complaints in contempt matters, CC number 17.
please.
Lata, SVT.
Complainant, my lord. Accuser filed a complaints affidavit, my lord, producing the endorsement. I seek for a week's accommodation, my lord. Sure.
Please.
18.
Same matter,
Same
my
one.
lords. Please. Great.
Number 19. The Girija AS.
We have complied.
Weeks
the
time, my lord, they filed a complaint affidavit. The client is, the complainants are telling the boundaries mentioned as per the, before the partition deed, my lord. So just seek a
My lords, we have complied, my lords. We have
A week's
filed the
time, my lord.
affidavit also producing the Kata minutes.
E-Katas.
E-Kata minutes. It is translated copy. It's from page number 12 onwards, my lords. Lordship. The Lordship may kindly see the names of the complainants. T.S. Rangaraju.
A week's time, my lord. They're telling the boundaries mentioned are wrong and before the partition, my lord. They've partitioned in 2015, my lord. I think the boundaries mentioned, I received in the morning, I sent it to them. They said there's a small clarification regarding the boundaries. A week's time may be granted, my lord. They're saying it's before the partition, it's not as per the partition deed, my lord. The honorable single judge had said, as per the partition deed, Kata should be issued, my lord. The complainants are instructed me saying that it's before the partition, the boundaries are mentioned, my lord. A week's time may be granted, my lord.
Lords, we have stated in our affidavit that it has been done as per the partition deed. It's
A week's time, my lord. I'll clarify with the complainants and assist this honorable court. Just a week, or maybe a 2 days time, my lord.
please.
Obligement, obligement.
My lord, my lord, on submission, my lord. Accuser number 3 filing his
2 and 3. Shailesh, Shailesh, madam. The partition, boundary properties and the kata properties are not matching, my lord. The kata. Properties, my lord.
Lord Smith.
Obliged.
My lord.
Obliged.
This is the copy of an affidavit by the accuser number 3, my lord, along with the accuser number 3, commissioner, my lord, CMC. It's an katas and all.
It's the same.
Similar, same. Accuser number 3, my lord.
Obliged.
Seal number 20. Arun Govindraj.
My lord, I'm appearing for the complainant father in this matter. This is a matter pertaining to non-compliance of visitation rights that were granted to me on the basis of a joint memo filed by both parties. My lord will find the joint memo at page number 54 of the petition copy, my lord. Typed copy of which is at page number 57. My lords may see that the respondent who is the accused before the court has signed the said joint memo. The order was passed based on consent. However, she has failed to comply with the same, and I've had no visitation rights for almost a year now.
For the accused, Your Lordship. Your Lordship, I want the matter to be passed over. The arguing counsel will address the arguments, Your Lordship.
Much obliged.
Number 21. The Pawan Chandra Shetty.
My lordship, I am for the complainant, my lord. My lord, due to medical emergency of the family member of the senior, my lord, senior not able to appear, my lord. My lord, kindly a short date may be given. My lord, day after tomorrow, my lord. Much obliged, my lordship.
Hearing on application. Seal number 22. Ramachandra Halina Tota.
I'm for the appellant, your lord. Kindly pray for time, my lord, maybe next week sometime. Yes.
My lords, one humble submission, my lord. In the last date, they undertake to remove the construction which is deviation, my lord. The deviation of the construction, they undertake to remove that, my lord. The appellant has undertaken that the amount of deviation which is there, they undertake to remove the construction, my lord. Kindly maybe mention that in the order sheet, my lord. I am for the respondent number 6 to 8, my lord.
For the respondents 1 to 5 BBMP, my lord. This matter pertains to a building.
Yes, no, my lord. The appellant has undertaken in the last date, my lord, that they are ready to remove the construction which is there in the deviation.
No, my lord.
Appellant, man.
He's the complainant, my lord.
Yes, ma'am.
My lord.
A building has been constructed, my lord, in violation of the building plans.
My lord, the senior is
which,
held
my
up in
lord?
another, senior is held up elsewhere. Kindly maybe had next week. Sorry, my lord. Yes, my lord, I want time next week, my lord. Next week, any date, my lord.
Acha, please.
My lord, it may be kindly passed over. I'll come back with the latest, my lord. Yes. Yes, my lord.
My lord, I am for the respondent BBMP, my lord. A building has been constructed in violation of the building plan, for which, my lord, the learned single judge, my lord, in violation of the plan, my lord, for which statutory notices had been issued. And the constructor, Under my lord, he was there. 248 notice. 248, please, my lord. What happened to that process? My lord, subsequently, my lord, the construction of the building has been stalled, my lord. He had subsequently, my lord, subsequent to the filing of this writ appeal, my lord, he had approached the chief commissioner by way of a statutory appeal.
As per the direction of the single bench, my lord, they gave before the DVMP chief commissioner, my lord. Even that appeal also is dismissed, my lord.
It's dismissed recently, my lord. I will place that on record.
My lord, passed over. I'll come back with what is the latest because undertaking was given on the last date.
What is the outcome of appeal? My lord, that has been dismissed.
That has dismissed.
That has been, I'm instructed, my lord, that the appeal before the chief commissioner has been dismissed. So we'll have to take action in accordance with law. And in the meanwhile, on the Action in accordance with. in law, on the last occasion, my lord, the learned counsel for the appellant stated that he would voluntarily remove the deviated portions, my lord, for which it was posted today. He would voluntarily do that, is what he had stated on the last occasion. Let him come. Keep back. Pass. Pass on.
Very
well.
Acha, please.
It's about 23.
My lords, this is the matter. And my lords would remember that the BBMP had filed a proposal for an MOU for lakes to be handed over to different entities. And we have filed our objections. Our main objection is that as per, in fact, there is a previous order of this honorable court that MOUs cannot hand over any lake to a corporate entity. So our suggestion is you may give the lake to a non-corporate entity, a citizens group, an NGO, a residents association for any.
If they're ready to fund it, my lords, we have no objection.
Why should we fund it?
Then that's the whole point. They are not ready to fund it. They are ready to advise, my lords.
EBMP has the operation to do the lakes. My lords may just see, I just want to point out one previous order of this honorable court dated 4/3/2020 in this very matter. There is an order dated 4th of March 2020. Yes. 4th March 2020.
2020.
Yes, it is in old order.
It's a lengthy order. I'll pass on.
Just,
Sorry.
there is an order of 4th March.
That is
Where
not-
at-
they are not short
1
form.
minute, sir. 1 minute, sir. There was, in 2020, some MOUs were brought to the attention of
10th March.
4th March, ma'am.
2020.
4th March 2020. If my lords can see para 9 and 10, paragraph 9 and 10, ma'am. Para 9 and 10, if I may read out, the par- my lords have found it. In fact, the orders itself is run into more than 200 pages. May I read out the order, my lords, just for my.
Can I give a copy, my lords? Put up it. One more copy. I'm sorry, I just got one copy.
If the other copy that my friend Mr. Mohan also shared. May I read out para 9 and 10, my lords? Para 9, the affidavit of state government brings on record another disturbing feature regarding the memorandum of understanding executed by the state government with corporate entities as per the draft annexed on pages 118 onwards. The draft indicates that the state is virtually parting with lakes to private corporate entities. 10. We direct the state government to place on record, along with the affidavit, the copies of such agreements already executed. The issue of the legality of the agreements will have to be considered. Prima facie, it appears to us that by the execution of the said agreements, the state wants to shift its burden of maintaining lakes to private corporate entities. Unless the legality of such agreements is examined, we cannot permit the state government to execute such agreements. Therefore, we direct that till further orders are passed, the state government shall not execute any such MOU with any corporate entity. However, this order will not, 1 minute, sir. This order will not prevent state government from taking funds from corporate entities for rejuvenation of lakes. Now, my lords, there was a clear order passed that the government or BBMP or anybody else will not enter into any MOUs with corporate entities. The entire matter is for looking at encroachment on lakes and stormwater drains. A whole series of orders have been passed for detailed directions issuing to the government and to the BBMP. Now, on the last occasion, the BBMP submitted a policy that they have made seeking that they want to enter into MOUs with different entities. And if the MOU policy and this format can be seen, the entity is including group of citizens, associations, resident welfare associations, cooperative societies, companies, and NGO. And in fact, it speaks about, in fact, handing over the lake to these entities. Our submission, my lords, I have filed my objection saying that such, in light of the 4th March 2020 order, no MOUs can be executed with corporate entities. The issue is that the state government and the BBMP are the custodian of the lakes. Whether they have funds or whether they don't have funds, that is a larger issue that they may have to address. But MOUs cannot be executed in a manner where the lakes are handed over to corporate entities. If it is a residents group or a citizens group, which is merely looking after any debris or garbage or cleanliness of the lakes, that some citizens groups may be willing to do. But to include an entity which is within the definition of entity, which is a company. In fact, this honorable court by the 4th March order, in fact, has stated that cannot be done. We are just handing over our environmental resources to corporate entities for their use. This order is very much in force, my lords, my submission. 4th March 2020 order is very much in force. At that time, there were about 7 or 8 MOUs that were, in fact, brought to the attention of this honorable court. And those MOUs were, in fact, held to not be in operation till this issue In fact, on the next page, at para 11 also, my lords, the order states that we direct the state
So
government
they
to
are
file.
seeking 100% funding.
Malot, here is the case, Malot. Today we have 205 lakes, Malot. We need around 60 to 70, 205 lakes in Bangalore, in and around Bangalore city. We need approximately around 60 to 70 crores, Malot, to at least just maintain. For developing and further sustaining, we need far more funds, Malot. We are not handing it over as per the new policy, Malot, which I'll place before your lordships, which has been given to them. The question of giving to any corporate entity or for transfer of title is not there. It's only limited, Manoj, if your lordship see the policy, limited only to the extent of maintenance. So, your lordship may kindly see, Manoj, what is important in this is a policy, Manoj, which they have object. Your lordship may kindly see 3.5. 3.5, Manoj. Contribution, what their argument, the whole case is, Manoj, 3.5, what they're saying is it should not be taken, money should not be taken from corporate companies' contribution. Second, Malot, 3.6, they want as entity, they want to delete the name corporate companies from the definition of 3.6 entities. Then further again, Malot, they're saying that clause 4, they're saying, Malot, we should not create assets. This is the objection which is forthcoming, Manoj, from their reply to this policy. Manoj, here what we are doing, and one other important aspect, Manoj, can I request clause 16, Manoj? Clause 16. The provisions of any service, clause 16, the provisions of any service in respect of lake shall not entitle the entity to privatize, derive profit from, excluding the public from, or monopolize the lake in any manner. The lake shall remain open to the public under the custody of the BBMP in the same manner as it would have been. No MOU has been entered into. The terms of MOU will be in every case be restricted to a period or term as set out in the said MOU and or general condition, and the entity will have no right to continue provider asset facility beyond the said term. So, Maloj, it is only for the contribution for maintaining this, Maloj. If the NGOs can do it, Maloj, why not a corporate entity? Maloj, they are not ready to fund. They are not interested. Maloj, it looks like a negative. Maloj, they are not interested in maintaining the lake. They don't want to fund it, but they want to control the lakes. Rejuvenation, desilting, all this is a process which costs money on day-to-day basis and in the long-term basis, Maloj. It cannot be done by one individual. So therefore, Maloj, what was frowned upon by the court earlier has been taken care of in the new policy, subject to your lordship's approval or any other conditions if your lordships feel has to be included, Maloj. We are open to it so that it does not go into the hands of any individual, corporate entity or NGO, my lord.
May I just respond, my lords? My lord, sorry.
Just one statement
Sure,
after
sure.
that. Ultimately, my lord, we are interested in maintaining the lake. For maintaining the funds is the basic important, my lord. Throughout the country, I'll just place it before your lordship, my lord. If public-private participation is there, why this public-private? Because the funds comes, there are CSR funds, my lords. It is used for public purpose. To say not to take for CSR funds which are public for the purpose of public good, my lords, is, I mean, I don't stand. Let them, any condition, restrictions insofar as going to the hand of the corporate. I fully appreciate my concern insofar as that. That will be taken care of, my lords. Nothing will be handed over. It will all be in the BBMP control except for providing maintenance.
May I just respond, my lords? My lords may kindly see the MOU format which has been handed over. Kindly see 3.6. 3.6 entity is defined. May I just point out 2 or 3 concerns? Entity shall mean a group of citizens, associations, including resident welfare associations, cooperative societies, company, NGO, which are duly registered. Thereafter, my lords, kindly see para 4, clause 4.
The money will be, fund will be like, remain with the corporate entity.
I'm sorry, Manoj.
The fund to be spent
Please, Manoj.
for maintaining and developing the lake
Please, Manoj.
will remain with the corporate entity or will
No,
come?
no, what we are proposing is, my lords, for example, my lords, let us take Alsur Lake, one lake we have to develop. We'll set out what are the works to be done for the lake, for example, benches, toilets, whatever. We will also, so that there's no mismanagement of funds, my lord, that they'll engage an agency to complete that work. It is only to that money will go to that agency, they'll implement, will give the time limit to complete. Neither we will take the funds because I don't want misuse from the BBMP for the, from the lake for the, what is being utilized. So that entity, it may not be.
Those things will be part of the agreement.
Everything will be part. Your Lordship may explicitly and let it come constructive suggestions. We will put it in the agreement itself, my lords.
May I make a submission, my lords?
From 20.
Could my lords just?
Clause 4 answers your Lordship's question. Clause 4, my lord. The entity with the prior approval of the elect to incur expenditure from his own funds on behalf of benefit to develop, create, provide a facility or asset to be used by the BBMP for its lake or to offer services on behalf of the BBMP to develop and maintain lakes. Illustratively, such assets could include installation of benches, construction and maintenance of public restroom, installation of water treatment plants, providing aerators, floating islands from the lake rejuvenation, and creation of park, open spaces adjacent to the lake, etc. Illustrative services for the purpose of lake maintenance will include the housekeeping, arrangement of cleaning lakes, maintenance for the public space in the lakes. So therefore, my lord, there are 205 lakes. There are no dearth of people coming forward to do it, my lords. Let if the NGO or whoever is coming, we can give preference to them.
My lords, can I just make one submission? My lords, kindly see para 10 of the last line of para 10 of the 4th March 2020 order. The last line of para 10 in the order, page 5, says, we direct that government shall not execute such MOU with corporate entity. However, this order will not prevent, last line.
Court officer. Can you take court officer?
My lords have found it. Para 10, the last line. However, this order will not prevent the state government from taking funds from corporate entities. Now, I'm only making a submission that this honorable court has in fact said that no MOUs can be executed with corporate entities. Yes. Now, if my lords were to see para 4 of this MOU, can I just read out para 4? It says the entity. May I just read out para 4 and the implication? The entity, which includes a corporate entity, will elect to incur expenditure from its own funds on behalf of and for the benefit of BBMP to develop, create, provide facility or asset to be used by the BBMP for its lakes, or to offer services on behalf of BBMP to develop and maintain the lake, Illustratively, such assets could include installation of benches, construction, maintenance of public restrooms, installation of water treatment plants, providing aerators, floating islands for lake, in fact, there are orders passed by this honorable court that floating islands were to be removed because these activities, my lords, in fact, are endangering the lakes and creation of parks and open spaces adjacent to the lakes. In fact, my lords, in these previous MOUs which were brought to the attention of this honorable court, these parks and walking areas were created by corporate entities where they had in fact executed them, and they had made those park entries restricted. They had put costing and entry fees, which was in fact making it inaccessible for members of the public. Now, one may say that all that will be taken into account, but in fact, after the MOUs are executed, the entire lake is given to maintain and develop. Therefore, this honorable court held that we don't want MOUs with corporate entities. You want to take donations or CSR funds from them. Corporate entities can always give CSR funds to BBMP. There needn't be the responsibility, my lords, with great respect, of maintaining lakes in the city are of the BBMP. If BBMP does not have funds, BBMP has to raise funds either through the government or through other resources or from corporate entities or any other entities. Petitioners have not come and said, give us the lakes. But there cannot be, our concern, my lords, is that lakes, 1 minute, sir, the lakes cannot be handed over or given or controlled in any way by a corporate entity, because the corporate entity will have corporate interests at heart and not the interests of the lake. The lakes are the property of the entire city. The lakes are, my lords, commons. There should be, my submission, let there not be any MOUs, my lords. With great respect, I mean, my lords, let there not be, okay, such MOUs with corporate entities. My lords, our submission is.
I appear for the.
One second, let the court.
They make one sub.
Oh, there's a Lake Development Authority itself, my lord. My lords,
if one are concerned, my lords, with the.
Your Lordship may kindly go through. We are open to any suggestions, my lords. Your Lordship may, what the objection is 3.6 may be kindly seen, my lords. The whole objection is toward of corporate companies in 3.6. If, I mean, means group of citizen association, including resident well, cooperative societies, corporate companies, NGOs, when everybody else can be there, what is bad about a corporate companies, if I may ask myself? Are they, I mean, if they are funding the project, they are helping to maintain the thing. I mean, it's a cynical approach saying that corporate companies are bad.
Then who will you select?
That is why, for example, it's like this for a taking again 25 crores is required or 1 crore is required to maintain. So company may not come full give 1 crore. Somebody may say that I'll give 10 lakhs, 25 lakhs. We'll make a consortium of all these people together. If an NGO comes, it will include everybody so that our idea. In fact, I asked the very same question, my lord. So that what is the work required to be done in a particular lake? We'll see, draw down the work. What is the costing of that work? Then we'll put the advertisement who's ready to take up this work.
Then we are giving out our lakes to people with the biggest pockets.
What? I don't know why. I don't understand.
To say that whoever has the deepest pockets.
Kindly go and maintain these 205 lakes if you are so concerned.
It's the BBMP's job. It is
participation by argument, my lord. Participation on ground we need, my lord, not by giving sermons.
My lords, there are decisions also I will place on record to assist my lords.
My lords, I'll place similar policy of other states also, my lords, which is akin to this. It is not that, my lord, the again, the fact that we are giving it to corporate entities is a wrong assumption. Neither the policy saying that if your lordship, I'll point it out, my lords. That's all, my lords. And maintenance and development, that's all.
Cannot be handed over to the.
It won't be.
Because your Lakshmi kindly see, we have a Karnataka Lake Conservation and Development Authority of Land Development Authority Act is there, which wherein in page 5, your Lordship, in the memo which they are filed by the government, they are not approved it actually. Kindly see page 5 of the
This
memo filed
petition-
by the government. That filed on 20th March, your Lordship. My Land Advocate General referred to that. Page 5, your Lordship. Now coming to the page 5. In the memo filed by the government for taking permission of the policy, the policy.
My lords, one thing, my lords, to assure to the court, my lords.
Page 5.
We have noted which we have.
I think what my learned friend is making a submission is that even in this policy which the learned AG has submitted, there is a noting that the Karnataka Tank Development and Conservation Authority has actually held that such MOUs should not be
Maybe it's continued till the matter is sorted out by the Honorable High Court.
That is
This
why,
the
ma'am.
opinion given by them.
The
According to their opinion, now they want to frame this policy, which is also, the BBMP has no power under the new BBMP Act also, your Lord. That's what I filed my objection to that memo also, your Lord. Kindly look into that memo, because they don't have power. Because your Lordship may kindly see, section 318.
Is this policy contrary to any legal provision?
No.
My lords, we will make those submissions. May I just?
Just one
make-
submission with my learned friend's
on the
permission.
Karnataka
Because
Tank-
BBMP is not the owner of the lakes, your Lord.
My lords,
They are Karnataka Tank Conservation and Development Authority are the custodian. They are only to maintain the lake, it has been handed over to BBMP.
The land of the
Maybe.
lakes will
It
vest
does not
in you.
belong, it belongs to the government.
correct.
Oh.
Government,
We cannot, BBMP cannot formulate this policy. That's my
my
responsibility.
lords, it is.
In fact, your Lordship, they could have sought modification of your Lordship order.
But then make it a tripartite agreement.
We can do that, man. All these are niceties, my lords. The weekend, we are agreeable.
Modification of your Lordship order of 4th March 2020.
So essentially,
Definitely file an application.
why you are objecting to such kind of,
They file.
One submission, my
why
lords.
you are objecting?
My lords, let me respond very simply. My lords, in fact, raised a very pertinent question. Supposing a cooperative society or any other organization and a corporate entity both apply, then who will it go to?
Naturally,
Then it
that
will-
is the idea, that is the anxiety.
Then if that happens, let us just take an example. Or if 2 or 3 corporate entities apply, if real estate developers apply, who will it go to? It will go to the entity with the deepest pockets. Now, if it goes to an entity where the only interest is how deep your pockets are, my lords, the concern is, which even the Honorable Supreme Court has held in the MC Mehta decision, which I will place on record if my lords want to hear, that ultimately the interest is to protect lakes and these natural resources for the public and for our society. When entities with deep pockets get in, my lords, their interest will be monetary interests and not necessarily to preserve the lake. In the garb, the BBMP may well say, we are giving you the possession to make a road, to make a park, to make benches, to make the boundary, etc. But where it will be encroached, where their own interests will come into play, my lords, and where the interest of, in fact, preserving the lake. Ultimately, my lords, we want the lakes to be preserved and not encroached so that it is there for our next generation. That is the interest. It is not to come in the way of any development. And therefore, this Honorable Court, in fact, said, you can always take money. CSR funds, companies are giving money. They have to donate money. And BBMP can always take money. BBMP can take the money, or the Tank Development Authority can take the money and do the maintenance themselves if they don't have funds, because the job is for BBMP to maintain the lakes, my lords. We don't want the maintenance and any work on the lakes to be done by an entity where ultimately their interests are not of preserving the lakes. That is the concern. My lords, there are decisions on this point.
But those who are giving the funds would like to have their identity reflected at the place.
If they want to
One
put even the
submission, madam.
name of a corporate entity, there is no difficulty for BBMP to take their funds and maybe put some name. This lake has been developed by the funds of so-and-so company. My lords, we don't want the lake to be given to the company even in the garb of putting a bench. Whether they put a bench or whether they encroach part of the lake and make a larger pathway, my lords, who is to control it?
Your Lordship, with your Lordship, kindly, my lord, this petition is of the year two. My lord, this. Well, with your,
We will be opening a Pandora's box, my lords, is the genuine worry.
They have not approved it also.
this is a 2014 petition pending past 10 years. 2020, the order has been passed. My lords, because of this petition and this, my lord, the development of the lakes and the rejuvenation of the lakes have come to a total standstill, my lords. In fact, my lords, your Lordship may kindly see your Lordship asked a question, my lords. Court officer.
Yes, sir.
KTCD Act.
Theory has done the study regarding into. That is not, they have not taken up that issue till date for BBMP. They want to divert the attention.
Page 26.
In fact, detailed orders have been passed for the last 10 years
Your
and
Lordship,
not
I
an
can-
issue of any funds issue has been.
Kindly see page 26, my lord, of the Karnataka Tank Conservation and Development Act 2014, my lord.
Two 2015 amendment.
The amendment, sir. Just show
No,
me.
this is the old 15.
No, you have the new one.
That has been amended.
Verify.
This is the one.
Just give me the act.
Karnataka Act is a 2018 amendment.
Your Lordship may kindly see section 3, my lords.
Chief Minister.
Who is nodal officer?
Your Lordship,
Yeah.
now that has been replaced by the 2018 amendment, Your Lordship.
2000 amendment.
2018.
Amendment is only to
2018.
one clause, my lords. It will not make any difference, my lords. 2014, its amendment is to only one clause, section 12(3), my lords.
It's not there. Name has been changed.
No, that is the tank conservation.
It is changed, madam. It is not. Now it is called Karnataka. Tank conservation.
Yeah, and Development Authority.
Yeah, that's all. 2018 amendment.
What are your objections to any of the clauses? Then we can take care.
Yes, in fact, I've given my objections to the
We are
clauses.
quite-
1 minute. I've given my objections to the clauses. My submission, in fact, in my objections, which I've also filed, was that please remove the coverage of a corporate or a company from the entity so that the entities with whom you enter into MOUs are non-corporate and the facilities to build, etc. should not be there. It can just be for services to protect, remove any dumping of garbage, all of that from the. I have given our suggestions, ma'am.
I would request my learned friend to also see that how they'll fund the projects. 205 lakes, we need 650 crores. I would suggest if they're really interested in the lakes, to provide for funding also on maintenance also.
If they want to take funds from CSR companies, they can take it, my lords. Nothing prevents them.
Your Lordship, BBMP Act 2020.
Based on this policy, can you prepare a
MOU, my lords. I'll do that. We'll place it before your lordship.
one standard MOU,
On standard, we'll do that.
subject to variation in customized cases?
Please, format for all
Not
the,
yes,
all the, without any changes which we'll do, so that henceforth we'll enter into only those kind of agreement. In terms of the policy itself, we'll place it. Your lordship may approve it. On that basis only, we'll do it.
And one suggestion which strikes us, especially my brother, that instead of nodal officer, let it be a nodal agency.
Manoj, that is why section 3 is there, Manoj. Your lordship may kindly see this one. That is what I wanted to. This is the Karnataka Tank Conservation and Development Authority Act 2014. Manoj, there is a authority, Manoj, which overlooks into all these lakes, Manoj, which comprises of three, Manoj. Minister for Minor Irrigation, Principal Secretary of various departments, Manoj, at serial number K.
So let this be a nodal agency.
Please, Manoj.
Then your anxiety is taken care of.
My lords, allow me, while they are giving a draft as per my lord's suggestions, allow me to also place on the same time some observations of our Supreme Court, which say that corporate entities should
All
not be.
objections, all
Yes.
suggestions are welcome.
Yes.
Positive
And
suggestions.
says that our concern, my lords, is that MOUs with corporate entities itself is in principle ought not to be, of course, we are in my lord's hands, should not be permitted. This does not restrict them from taking funds. This does not restrict them from taking any funds or donations if they are in need of funds. But to allow corporate entities to take over any maintenance of the lake, my lords, is a concern. Allow me to place those
Only
proceedings.
anxiety to be addressed is that the system works and no vested interest is created.
Absolutely, ma'am. And we'll see that in the MOU, there is no taking over of any lake by
Taking
anyone
over
at all.
By
The state and the BBMP.
My
will
lords,
be-
if they want to take, the first concern that even comes to our mind, my lords, is that what is this tearing hurry that they want to get corporate entities to do
10 years,
on the lake?
2014 to 2024 is not sufficient, I feel, Manoj.
The work of protecting and preserving is of the tank authority, and one of the designated officers is of the BBMP, and BBMP has been issued directions to maintain the lakes. Now, my lords, if they are having any difficulties to maintain the lakes, if they need any funds, they can raise it from corporate entities. But to say that we will auction this lake.
no, they will not auction. That will take. Therefore, let the MOU come.
We'll do that, we'll do it.
And we'll place on record some of these decisions.
Let them
and
look
we'll-
into the MOU, then file objection, not before looking
I
in.
will only file objections when I get
So,
a draft.
And they should, if they,
Meantime, I will also place some important precedents for my lord's consideration, where certain cautionary notes have been put, where corporate entities working on lakes may be a practice that should not be encouraged. I will place those, my lords. Before, and then my lords may take a decision on consideration.
We'll take all suggestions together and
Yes.
then finally pass.
Great.
On submission, Lordship.
Humble submission, my lord. I appear on behalf of respondent number 14 in this matter, which is a citizen group, which has been maintaining one lake, Puttenalli Lake, for the last 10 years in collaboration with BBMP by way of MOUs. And we have placed on record all the sample MOUs which the citizen group has entered into with BBMP, and they have carried out various activities for BBMP. They have
So
also
when
raised
it is
funds.
Working will not disturb it.
Manoj, we are at your
But
lordship,
we have,
whatever,
our
let them
MOUs have
place
been
to our- my lords.
discontinued.
Where it is
My lords,
working.
we
Our
have-
MOUs have been
We
discontinued
have no
because
particular
of the
interest in
order of
any
the
one of
Honorable
them,
High
Manoj.
Court.
We have welcome any suggestion, what your lordship says and what my learned friend says. Only our concern is 2014 petition from 2020 is the order. Lake should be maintained, Manoj. Keeping that open, Manoj,
We'll put an end to
we'll
this.
put an end to it. That's
My
all.
lords, the lakes are in their maintenance, yeah, as per the directions of this honorable court, are nowhere near completion. I mean, we are just, my lords have in fact passed very detailed orders for each of the lake. In fact, NEERI was appointed, and over a period of 1 year, my lords, NEERI, which is a central agency, examined, inspected each lake, each of these 200 lakes, and gave its detailed reports as to what has to be done in each lake. And my lords, when we engaged, BBMP has paid a huge amount to NEERI to do this inspection and to do this study. Certainly, at least the directions of NEERI should be implemented so that these lakes are in a good stage, my lords.
Your Lordship, that order is passed by this court on 18 June 2019. Paragraph 35 it was referred, Your Lordship. 33, hence we direct the government to look into the NEERI report. Paragraph 33.
And in fact,
We direct
only
the state government appointed CSR, based on that they have appointed actually.
My lord,
Then they have submitted the report.
DPR is prepared
That-
when the project comes up, my
Terms
lord.
of that. And court also came down heavily when they wanted to construct an island in Subramanyapura.
one of the lakes. There was an island
Lake, they want
that was to be
construct an
constructed.
island.
My lord,
The court came down heavily, even in Bagalmutta Lake where the 23.4, there also they are writ petition filed based on they formed the island, which they said it cannot be done. And even the pollution control board inspected the place and given the report. And other
my lord,
318 of the BBMP Act 2020, power to make bylaws, they have the power, but not for the lakes, basically. They
Well,
don't have power. Because there is a Karnataka Tank Conservation Development, they are the authority, they can do it, and they can frame guidelines and other thing, not the BBMP. Because BBMP only, it has been handed over by them to BBMP to day to day. Not, it cannot
Just
stretch
one-
beyond that.
just once a floating island doesn't mean that we're creating islands, my lord.
Because functions of the authority.
This body has some role or not?
Please, my lord.
The body.
It has got functions. Your lordship may kindly,
Section 5, Your Lordship.
your lordship may kindly.
Karnataka Tank Conservation.
Please, my lord. Your lordship, what is important in this is, my lord, section 6,
Five-
power of the authority, subject to provisions of act, to cause enter upon authorized officer to enter upon the land survey demarcate, to receive grants, donation, contribution deposits, to grant approval to any project proposal made by the government department or organization or to the person interested in developing, maintaining, conserving or protecting a tank, and also take up activities on its own, which shall be approved by the government, to invite experts. Clause 12 is also important. Acts prohibited in the tanks, my lord. So there are certain regulations which are prohibited also activity.
So MOU can be approved by this authority
My
also?
lord,
Yes, my
section
lord.
5.
And one statement, my lord, the floating tanks are not what we are, floating islands are not that we are creating islands. It's a machine which takes the, cleans the lake, my lord, which goes around cleaning the lake. It is not that we are creating an island in the lake. It cleans up the lake. It's a floating machine kind of which take out debris or whatever is thrown into the lake, plastics. My lord, let them, therefore, my lord, my suggestion is I'll give them the MOU, let them add clauses with their apprehension, not argue the matter. Let them put whatever clause they want.
That is right.
We are open to it, my lord.
As Narendra Rakan read this
46
section 6
clearly
also 5.
bars delegation of power.
BBMP has no role to play it. It is for the government to take a decision based on the.
I'm appearing for the government also. I'm appearing for the government.
Not the, BBMP cannot make any policy on it. It's contrary to that.
My lord, section 46 of the Karnataka Tank Conservation and Development Authority Act says that the powers of the authority cannot be delegated without any notification. The entire CILC policy which is now being proposed is effectively a sub-delegation of the powers of the authority.
Pursuant to the last order dated 9/7/24, passed by the court, when the proceedings of the present public interest petition are taken up today from a learned Advocate General, Mr. Sashikaran Sethi, produced for perusal of the court. A policy called Brahat Bengaluru Maha Nagara Palike Community Involvement for Lake Conservation Policy 2024, which inter alia contemplates to hand over the maintenance and upkeeping of the lakes in the city, which are stated to be 205 in numbers, to the entities defined in clause 3 point in what we'll call in rule or regulation, in clause 3.6 of the policy. In course of the hearing, Learned Advocate Miss so and so and Mr. so and so expressed certain apprehensions about entirely handing over the lake and the possession thereof to the corporate companies, which is one of the entity. Full stop. As against this, it was clearly pointed out by, on behalf of the state, that the policy in no way contemplates handing over of exclusive possession to the corporate entities, but their participation and the funds are invited for better maintenance, for maintaining the lakes in a better condition. Full stop. Learned advocates for the petitioners wanted to put forward certain suggestions in relation to the clauses of the policy. Full stop. For that purpose, time is granted, stand over to 24th November, September.
Earlier, within 1 week, I'll give the copy, MOU to my learned
I
friend.
may
my lord.
take some time to
No,
respond. as well.
yeah, therefore I'll give within 1 week, I'll give it to my learned friend, my lord. Let them respond to that, my lord, so that then we can place it.
15th
Not,
September or
advocate
something.
States,
15th is
Advocate
Sunday.
General states that within 1 week, in the meantime, within 10 days, a specimen memorandum of understanding will be prepared and copy shall be handed over to the councils for the petitioners in order to enable them to
I know that need to.
formulate their suggestions.
My lord.
And file any objections.
Within 1 week thereafter, my lord, the reason is.
Where is the tearing hurry, my
My
lord?
lord,
There are-
tearing
Where is the tearing hurry?
2014, I don't understand, 10 years is, 10 years is not a tearing hurry, my lord. We are concerned with lakes.
They are not.
My lord,
aware
fix
the order
any
of
date. I have
18th,
My lord, lakes have to be.
2019 till date.
So there are no objections, only
They
suggestions.
want just divert
My lords,
the
we will,
petition, basically.
my lords, we will submit our objections. It's
I
up to my
understand, my
lords.
lord, they are interested in lakes.
We are in my lord's hands.
Once
This is the
update,
case.
We had about 900 lakes. Now, after there was only 200 lakes are there.
If you keep it for 10 years, there'll be no lake also, another 10 years.
My lords,
there'll
some
be-
date may be fixed.
This is not to be argued in fact.
Absolutely, my lord. And we are open to any suggestions, my lord, any suggestions, my lord.
My lords, that is, they may be open, but when we give the suggestions, my lords, the suggestions are not taken. So it is,
Your lordship makes,
it's just to say
find
that
out
they
which
are
is a
open.
reasonable suggestion, my lord. Ultimately, my lord, whatever, if we are saying is not reasonable, my lord, your lordship may make
The date is.
We'll pass final order.
a final order on that basis.
Some date,
Date is given, which given? 24th,
24th.
24th September,
Grateful.
or it will be longer. Little
Earlier, my lord, because
10 September.
11 September.
grateful.
11. 11th.
It's number 24. Sumoto PL. It is number 20. We'll put it, cut it.
This matter,
there
my
is-
lord, is in regard to the implementation of the Juvenile Justice Act. In the first matter, my lord, I appear for the Legal Services Authority. This is a suo motu writ petition in respect of the implementation of the Juvenile Justice Act, my lord. On behalf of the Legal Services Authority, my lord, we had in fact filed an application seeking for certain directions in respect of the implementation of certain aspects of the act. The government had filed a reply to the same, and we have also filed a reply. My only request is, my lord, if my lords could see that application, because there are certain aspects that still remain to be answered, and that would require some intervention from this honorable court in order to ensure that the Juvenile Justice Act is being implemented. That IA, my lord, is IA number 1 of 23, which was filed by us. On the previous occasion, my lords had directed us to file some submissions, certain suggestions that could be looked at and considered towards the implementation of this act. If my lord sees our application, in that several of these directions that are being sought by us are already mentioned. It's at IA 1 of 23.
Well, Your Lordship, we would like to submit a supplementary affidavit. I would like to submit a supplementary affidavit. Yeah.
You're filing.
You're filing the affidavit or you on time? You go through the.
Please, my lord, I'll go through this. May I also request that my application, my lord, which was filed by me, seeking for certain directions, that also if the government could respond to specifically in respect of those directions, because what we have sought for, my lord, in our application is it's IA 1 of 23, my lords.
What is that? IA 1 of 23.
IA 1 of 23 is the application that has been filed by the Legal Services Authority, my lord. Where we had sought for specific prayers in respect of the implementation of the act. If my lords for a moment sees page 16, it has the prayers. My lord, what has happened in this is that the child welfare committees and the juvenile justice boards, which were to look into various aspects of the act, they were not constituted. So therefore, my lord, the first prayer seeks for the constitution of the selection committee for selection of the chairperson and members of the child welfare committee and members of the juvenile justice board. The second prayer, my lord, is in respect of ensuring that the posts of the chairperson and members of all child welfare committees and members of the juvenile justice boards are filled in immediately. The third, my lord, is seeking a direction to fill the vacant posts of the staff in the child welfare committees and the juvenile justice boards and the other childcare institutions. This including, my lords, the security staff. What was noted by the Legal Service Authority that there was a shortage in the security staff. The fourth is in respect of payment of minimum wages to the employees who are employed in the child care institutions. The fifth is in respect of the deployment of police personnel.
What is CCI?
CCI is child care institutions, my lord.
So both we will consider on
Please, my lord.
13th of September. Learned advocate Ms. So petitioner files. What is your file? Supplementary affidavit on behalf of the petitioner, which is taken on record, send over to 13th September.
Kindly, my lords. Next matter, my lords.
After recess will be.
My lords, just now, my lords, I'm handed over the objections. My lords may have it tomorrow, my lords. My lords, in the second, education matter, my lords. About, my lords, medical, sports quota, medical seat, my lords. We had tomorrow, my lords. Today only they filed.
Which is next with 25.
Please, my lords, 25.
That is some sports quota.
Yes, my lords.
It is
State
my-
filed the objections only, my lords. I'm
What is
going
the
to copy
urgent-
only now.
In this
Urgent
matter, my lord,
student-
Please, my lord.
Is it an urgent matter?
Yes, my lords. Now the
How?
counseling, my lords, is going to, my lords, commence. Anytime, my lords, that's the reason.
Day after.
Day after. Please.
grateful.
Sadiq sir. Sadiq sir. Sadiq sir.
Code officer. Code officer, I just wanted confirmation. Serial number 70, is it urgent? 70.
appointment for the government. Appointment for the undertake government. Selection by the KPSC. Yours is password are complete.
Code officer?
So 25 also adjourned, no? They have to do.
Code officer, serial number 70.
That is on 213. That is. No, not really. After the 213 have to mention it. Come on. What's your name? Name?
Yeah.
Code officer? Code officer, can you hear me?
Serial number 62. Kindly take up this matter any next week, any.
Pardon, which matter?
Serial number 62.
62.
62. I am for a petition in this.
So what do you want time?
Petition, yes, madam, I want that.
It is PIL.
PIL.
What is that? It is about what?
But there is no urgency in this case. They kindly fix the date. I'll argue the matter because today I'm not feeling well. That's why I'm requesting.
Not feeling well.
That's why, madam.
All right, at the request of Learned Advocate Mr. So and so for the petitioner. Send out to. When shall we give? 30th August?
Please, any date.
30th August.
Serial number 15, my lord. I am for respondent.
15.
15, 15.
One.
My senior is not feeling well. My senior is not feeling well. Kindly post the matter after 1 week. Kindly post the matter after 1 week.
Why?
My senior is not feeling well.
Who?
My senior, Your Honor, for respondent, V.S. Naik.
The senior is not feeling well, therefore you are also not feeling well
Yes.
in conducting it.
15, 15.
At the request of Learned Advocate Mr. So and so. When do you want?
Next 30th. 30th.
30th August.
Matter was heard on Thursday itself, Your Lordship.
Which one?
Serial number 15. Reservation of the land for the KPTCL there.
That Gomal land, 60 acres
Yes,
out of
yes,
29 acres. He's right. It is kept for orders.
It's kept for orders.
We'll keep it little earlier. Instead of 38, 27th we'll keep. 27. On that day we'll pass.
Obliged.
Two-third. Then keep back. Well, at 2/3.
Two 30 matters. Serial number 86. Mr. H.M. Muralidhar for withdrawal of writ petition.
I'm for the petitioner, my lords. I have filed the memo before this honorable court for withdrawal of the.
Learned Advocate Mr. Muralidhar invited attention of the court to the memo of withdrawal dated 12/8/24 filed on record of the petition, in which it is stated that during the pendency of the writ petition, respondents received order dated 11/6/24 declining to consider the claim of the petitioner. It was stated that since the said order is revisable, revision application is already filed. In that view, paragraph. The permission is sought to withdraw the petition. Dismissed as withdrawn. However, no opinion is expressed on the merits of the case and in respect of the proceedings before the revision authority.
87 also same, 87.
87.
Same revision, same order.
Serial number 88.
For complainant, my lord.
Respondent, my lord. Complied with the accurate issued end of matter. Maybe in fact.
Learned Advocate Mr. So states that the present contempt petition has become infectious. In view of the statement, it is disposed of as having become infractious.
Yes, that's it.
Passover matters. This one, serial number 5. Mr. Siddharth Padmaraj. Serial number 5.
That senior advocate is engaged in this matter. Or should we kindly have it next?
Senior advocate is not well.
No, he was engaged. He's in other court.
Okay.
This is only contempt.
You go to some other date. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26.
Next week.
30th August.
Grateful.
Time was asked for on behalf of the complainant in the second round of polling of the petition. Stand over to, full stop, stand over to 30th August as requested.
Seal number 10. Saurabh Bharti.
The learned advocate general seeks for a short accommodation to Friday or on 28th, my lord, 23rd or 28th of this month.
28.
Lords, may I submit?
28.
My lords, may I
There is
submit, my lords?
no issue, minutes. I have no objection, but there is an undertaking given by the additional advocate general that they will not precipitate, they will not put up construction that may be extended, minutes.
Construction has come to
Well-
some level.
We want to precipitate. This is that 6 and 7 constructing something. You can-
No, minutes.
My lords.
Construction has come up to a certain extent. Now it has come. to-
Date is a
this is-
contesting respondent.
this
minutes, and
appeal.
last date I took time, we took time, but
That handing over of the land to.
It has been handed over.
Church of South
yeah.
India. minutes.
Handed over and the interested work order has been issued. Contractor has undertaken the job. It has come up to some level.
My lords.
Advocate general doesn't want to hand over.
My lord, today that is little difficult.
No, issue is that it is my condition is my land, my khata
lords,
has
I
been
have
cancelled
filed
unilaterally.
My
But
lords,
any
may I
date may be given, my lords.
Learned advocate general wants to hand over or don't want to?
My lord, we want the cancer hospital to come up.
My lords, may I submit, my lords?
The ownership and possession is in dispute.
They are seeking ground on the.
My lords, I have filed the impleading application. If there is no objection, my.
I have
application may-
I have serious objections, I'll argue that.
My lords.
To be here
I have
without,
served it 2 months back, my lord.
you can remain
Third
present
last.
in course of the.
Undertaking may be extended, my lord's
28.
request.
10 of-
Obliged, my lord.
I apologize, undertaking may be extended, undertaking may be extended. Undertaking was given on February 20th, that has been extended from time to time,
What is the undertaking?
but that they'll not put up construction minutes.
My lords, our
20th of
work has
February,
been
there's an
stopped
undertaking.
From February, it has been stopped, my lord. There is urgency for our.
The request on behalf of the state government, stand over to 28th of August, full stop. The undertaking orally given on behalf of the state and recorded earlier, shall continue to operate till the next.
Obliged, my lord.
Seal number 13. TP Mutana.
I pay for the appellant, my lord.
Pay for respond number 2, my lords.
Here the appellant, my lord, that he has a forged signature of the customer and withdrew 24,500 rupees. And that even a handwriting expert opinion also he confirms that he has prepared challan with the forged signature of the customer. And there is a delay of 33 days, my lord, in this case. 33 days delay is there to filing the.
Delay. All right, notice written down.
Lords, may make a request, my lords. Lords, I appear for respond number 2, my lords. My name may be deleted from the array of parties because I'm a tribunal, my lords, and central government industrial tribunal, my lords, were pleased to observe in the first time when the matter was called out in the morning, my lords, that I'm not to be made a party.
Who said that?
Lords, my lords were pleased to observe in the first.
Say anything.
Lords, in fact,
Don't
this,
go by our saying. You are
Lords,
welcome.
I bow down, my lords, but there is
You are
one.
here, you are welcome. Assist the court. Don't
Pardon?
get yourself deleted. Why you want to delete you?
Lords, because may I just submit, my lords, there's in fact a 2016 Supreme Court judgment.
On that day will see. Notice written around 12th of September.
Obliged, my lords.
Seal number 22. The Ramchandra.
Yes. What is
The respondent number 6 to 8 in.
Yes.
They took the passover in the morning session, my lord. They have not claimed. The appellant has not.
Learned advocate for the appellant was absent in the first session when the appeal was taken up. Full stop. He was again not present in the second half. Full stop. The appeal was called out for the second time. The appeal could have been dismissed for want of prosecution. However, in the interest of justice, 10 to 30th, 30, 29th August.
Much obliged. Number 26. The K and Manjunath party in person. 26.
Learned party in person is absent. Love, what is that? Love? No. One PA was disposed of same day. Same time. उसका order मिल जाएगा. Be able to get that order. नहीं, we have this. Justice करा लेता है. ले लेंगे कि he was telling on that day the same matter, similar matter. Learned party in person is not present, stand over to 28th August. Who appears here? You are appearing. Learned advocate, learned additional government advocate, Ms. Nilofar Akbar would submit that identical public interest petition, similar public interest petition has been rejected by this court as per order dated so and so and so. Stand over to 28.
Cell number 27.
I appear for the complainant.
I appear for the accused in
They
this case.
keep taking time, your lordship. The reply affidavit has not been filed. The contempt was filed on 13/4/2023, your lordship.
Lords, I
Till
may be
today.
given a week's time, my lords. The correspondence are being
Every
translated.
time. Money is due, your lordship. Civic work was carried out by the complainants and the money is due from BBMP, your lordship. As per the learned single judge's order, the representation of the complainants had to be considered.
It is all, nothing beyond that.
Nothing beyond that, nothing beyond that.
You
Weeks
consider
time.
why you are
My lords, there
sitting
is
right
also
over such.
an inquiry, my lords, pending against the alleged complaint. There's an inquiry pending against the complainant. My lords.
Pass an order.
I'll take instructions and file a response, my lords. A week's time.
30th.
Sorry, my lords.
Will not grant time beyond 30th.
Yes.
30.
Please, my lords.
Stand over to 30th August in view of request made by learned advocate Ms. so and so and so for BBMP.
Yes, my lords.
Who would ensure the compliance or will file the necessary affidavit before the next date.
Obliged.
Please. Number 28. Mr. Pratham Yan.
The accused in this matter.
Page 21 minutes is the direction.
Six.
So page 20.
Page 20 and 21, my lord, is the. Now
Okay.
the kata, my lord, which has been annulled, has been set aside and the entries were directed to be restored. So far as the property tax, that has not been carried out, is the grievance.
So direction number 5.
Yes.
Lord, Direction number 5, my lord, it says it is made clear that the entries made in favor of the petitioners in the property tax register maintained by the respondent is only for the purpose of collection of property tax. There is no direction as such, my lord, for me to change the kata.
So entries
Is only for the purpose of collection of property tax, my lord. There is no such direction for me to change the kata is my.
no, the entry, you may be right, but we are just asking that entry is in the name of whom? Petitioner.
Lord, the petitioners, my lord.
Then what is to be implemented?
My lord, the kata, my lord, which has been cancelled so far the petitioner, that came to be quashed. Writ petition has been allowed. Now, the respondent claimed that I got the kata. Direction number 3 said, the fourth respondent is not entitled for any benefit based on the impugned endorsement. Then, my lords, the fourth respondent was also granted liberty to challenge the kata. The the direction number 5 is that the property tax register shall be maintained in favor of the petitioner for the purpose of collection of the tax. Now they can't, my lord, maintain the status quo ante prior to the impugned order when the petition has been allowed. They can't ignore this order, my lord. This is on 21st of September 2022.
Where is that order which is set aside 29/8/2000? It is there in part of the record here.
I'm sorry, we did not place it on record, my lord.
So what was that order?
I will place it on record, my lord.
So if that direction number 5 is flowing from that setting aside of the order, then you have to comply with.
I will seek instructions, my lord, but.
Produce the order.
Please.
You also see that if the
Yes.
order requires, then you.
Yes, my
With
lord,
the
I will.
necessary consequence, you have to comply.
Yes, my lord, I will.
So 29th? 29th.
Much obliged.
Number 29, Mr. Bharat Kumar V.
If the order passed by the learned single judge has been complied, but the allotment letters have been issued, I am told, my lord, that the sale deeds are also executed in favor of the complainant. But I could not secure the copies of the sale deeds, but my lord, the allotment letters, my lord, were.
Yes, we have got one.
Received. Allotment letter is received.
I did not seek instructions, my lord. I should seek instructions from union.
This is regarding allotment of alternative land.
Yes.
Earlier, some order was passed by us.
Yes. Lord, the order passed by the learned single judge.
No, by us it was any order? No. Direction was issued to the direction, the direction was issued to the competent authority of the Bengaluru Development Authority to allot alternative land to the petitioner as requested by the petitioner in his representation dated 2/02/2021. So when the contempt petition against the said order came up for consideration today, learned advocate, Mr.
Not, sites are allotted to him. And my lord,
Also stated that the site is allotted to the petition.
sites,
How many petitions?
but only.
Should the petitioner. What do you? You are no
Yes,
instruction.
my lord.
You don't have instructions?
Yes. With liberty, you can give us a liberty. If
What
they
you
did
mean?
not allow allot will revive
While
the.
learned advocate Mr. So-and-so could not dispute the factum of allotment as it is evident from the copy of the order produced along with the memo dated 2/7/24 by the other side. It was submitted by learned the petitioner that liberty may be reserved to what?
12 sites, sir.
Any liberty, for what? Liberty for what?
If they did not allow, will revive. If they did not allow, it, will revive the application. My lord.
It is allotted, sir.
12 sites are allowed. 12 sites are allowed.
Be direct. The necessary full stop in view of the above, since the allotment is made to the petitioner, the compliance is obtained regarding the directions of learned single judge. While disposing of the present paragraph contempt proceedings, it is provided and directed that necessary formalities which may be required to be undergone, including the execution of the registered sale deed, shall be completed within 3 months.
Please.
Within 3 months.
Much of.
Obliged.
About 30. We did a complaint.
The order is complied. I filed the compliance affidavit on 17th, my lord.
It is record or
Huh?
compliance if it is filed.
Filed on 17th.
Lord, in this complaint account has been received today, my lord. It pays for a week's accommodation to have the words with the client. I have received the counter affidavit today, my lord, at
No, one copy I sent it by post. Another copy I gave it today.
Team say yes. What is the direction? E-Katha by paying prescribed fee.
Yes. The direction is to consider the application and with the reasoned order. Allot
The online application for issuance of E-Katha.
Yes.
Respondent
it is
within 15
considered.
days. So E-Katha is issued.
No,
No, my
lord,
lord.
I rejected.
My lord, we have the manual.
By giving reasons, it is rejected.
Rejected.
Yes.
My lord, we have the manual
That,
kathas, my lord. Our contention before the
proceedings-
learned single judge was that, my lord, to issue the e-katha.
What is the
There was a
direction?
direction, my lord.
Annexure 5, on page number 5, there is English translation of Annexure 1.
Following direction was passed by a single judge. Following operative direction was passed by a single judge. In his order dated 30th 30 August 2024, which are subject matter of present content. Import the direction. 8:30. Yellow flag. In response to the notice issued paragraph by this court after quoting, in response to the notice issued by this court, affidavit is filed, affidavit of compliance is filed by respondent number 1.
Yes, ma'am. Thank you.
Respondent number 1. That's the Panchayat Development Officer. Where is the order? Where is it? And then full stop. Along with the affidavit. Endorsement. Along with the affidavit. Who has passed this?
The Gram Panchayat. Because direction is issued to the satisfied Gram Panchayat.
Along with
Gram
the
Panchayat
affidavit.
in its meeting
Along
passed
with
the
the
resolution.
affidavit. Is claimed, endorsement dated 31/7/24 is produced. Full stop. Since it is not reflected at all, paragraph, as to which authority has passed the said endorsement. क्या लिखा? It is not reflected. Since it is not reflected, that which authority passed the endorsement, the court asked learned counsel appearing for the respondent, who said it is by the panchayat.
Yes, yes.
Also,
This
there is
direction
nothing-
is issued to Gram Panchayat.
Nothing to indicate that it is passed by the panchayat, therefore the compliance affidavit and the endorsement pass is rejected. If the respondent is so inclined, he may pass it may pass the press endorsement in an official, with official nomenclatures within 1 week, failing which
I
will
could
be
not follow.
exposed to aggravated form of contempt, stand out to 30th.
My lord, these copies I sent to you.
No, this
The-
affidavit and the endorsement are rejected, though they will remain on record.
I'm could not follow.
31.
You file, we must know who has passed panchayat, there must be a letter,
I stated.
there
so,
must be a stamp, there must be a signature.
I stated in the. so, my lord.
Stating is no answer. Somebody.
No, I produced the
No, we
copy
are,
also.
Mr. Counsel, we are rejecting it. That is fine.
I don't,
Yes, you pass a fresh order. This is not the way to put forth an order of the panchayat. This is an order of panchayat or type sheet. We want an order of panchayat if it is passed, with proper nomenclature, letterhead, stamp, signature,
my lord,
official seal.
My lord, Gram Panchayat, my lord, by
No,
resolution.
Gram Panchayat must function as Gram Panchayat, not as individual. This is nowhere. You are the lawyer, you guide them.
Okay, consequent.
You guide them. You are the lawyer.
Okay.
Yes.
Consequent.
31. Mr. Reynolds.
My lord, I beg to represent my lord accused number 5. I am extremely sorry, my lord couldn't be present physically.
Yes.
Lord, so I
Lord.
appear for the aggrieved home buyers. There are 17 families in that. And the company who is the respondent number 5, they owe to the tune of 15 crores in this particular complaint. And there is a serial number 73 as well. In that also another 15 crores the company owes to us. And there are executions order of RERA, which was given in the year 2022, which was supposed to be implemented by the state government, but the state government has taken no
Lots.
action as of now.
May just
Every
make
time
one.
they would like to file the affidavits.
I
as
may be
such, my lord.
permitted to submit, my lords. Lords, in 73.1, we have filed our affidavit stating that there are no properties in the jurisdiction of accused number 2. So the Devnalli Tashildar may be impleaded because there are certain properties found in the Devnalli district. So I request my lords to kindly pass an order to directing the complainant to implead Devnalli
Lord, they are
Tashildar.
already
There we
there.
have attached some properties, my lords.
They are already there, my lords. I was also there in the 73.1. I have made them a parties because the court had already asked me. But the learned
So
government
you are
leader
seeking compliance of which directions?
of
May I just make-
execution orders, my lords.
283?
May I just make one submission, my lord?
Yes.
My lord, a contemporaneous bench of this honorable court has passed an order, my lord. All these matters came up for revenue recovery. The revenue recovery proceedings, my lord, initiated by the government, Tahsildar and DC were challenged before, my lord, the learned single judge. And my lord, in those cases, the challenge was particularly the government was trying to attach the properties which never belonged to the company. They were trying to, my lord, attach the personal properties. And a contemporaneous bench of this honorable court, my lord, passed an order that RERA should now first consider that against whom the revenue recovery proceedings have to be taken place.
My lords, due to the delay in
One
implementation of
second,
these
Renaud,
orders.
Renaud, one minute. May I just, my lord, I'll just, my lord, complete it in next 10 seconds, my lord. Now, it so happened before the learned single judge, my lord, the contention was also that if the particular unit which was allotted, which, my lord, the home buyers did not wish to take, is more than sufficient to cover the payment of compensation payable to them, only that could be attached at first. Disproportionate attachment need not be done. So this honorable court, my lord, directed for them to implead all those necessary parties who own the properties and who could be held liable. My lord, that exercise is being done before the RERA authorities now. The RERA authority are now directed to, my lord, pass orders against whom particularly the revenue recovery proceedings have to go on. That exercise is incomplete. Now, my lord, till that is complete, it may not be possible for the state, my lord, to go ahead with the revenue recovery proceedings, and in those proceedings, my lord, the complainants are participating. The RERA has to hear the matter they have impleaded by an order of the court, and their RERA, my lord, direction is to the RERA to hear the matter on behalf of the property owners whose properties are being proceeded against the in respect of revenue recovery. Therefore, my lord, that particular order and those proceedings, the details of those proceedings which are presently pending before RERA, my lord, we would like to place. My lords, may kindly grant us, my lord, 4 or 5 days accommodation, my lord, we should be able to place. In fact, my lord, efforts were made to place that. We are unable to get the certified copies. Only, my lord, it's my folded hand request that only 4 to 5 days may kindly be accommodated, my lord, within which we will place the documents.
My lord,
So
the
that, my
same
lord,
submission was made in the earlier hearing also. But the issue is, my lords, first when the execution orders are given from 22 to 24, these orders were not implemented. By that time, the company has siphoned off all the assets of the company. Now we are left with no other assets. Now we have to go behind the personal assets. That's how it has been, my lords. By the time we complete the process,
Lords, insofar as
my lords, I would like to say one.
in fact, my lord, we are ready to hand over
we
them
have-
the unit which they
My lord-
don't want to take. We, in fact, my lord, the unit which they have purchased long ago by paying only 20% of the money, my lord, now, in fact,
My
my
lord,
lord,
it's a humble
values
fact.
10 times more than, my lord, what they have been paid. They don't want to, my lord, take the units. And the submission of my learned friend that siphoning
have
off, my
attached
lord, it
certain
is not correct.
properties.
Not correct.
We have attached certain properties, my lords, by the accused number 4. And my lords, that affidavit is ready. I'll get it filed, my lords, as a status report.
Let them file. My lords, there is a fact to this case that respondent number 5 is the top defaulter in the state of Karnataka when it
No,
comes
this
to
is not correct. My learned
non-implementation
friend,
of.
let him not make such
Please,
submissions, my
I
lord. It
will
is factually incorrect.
I'll
It's
complete the
factually
submission, my lords. That he's the top defaulter as per the RERA.
Both of you are not for petition.
Please, my lords. They are for the builders, my lords. They have never implemented any RERA orders, nor the builders are returning our money. And the money is due to the tune of 110 crores, my lords. 1800 families have not got their houses booked in the year 2012. This is a decade-long fight they are going back. And now again we have to go back to RERA and again fight another decade to come back to this execution process again, my lords. So the implementation of this order by the state is very important and primary. Or by that time, the builder will run off with all the money, my lords. That is the issue. In the coordinate bench, in another case, the court has freezed all the assets of the company, the banks of the company. That is the liquid amount of the company. The company is unable to complete the project because they don't have the money. They have collected all the money from me a decade back. Now they don't have any such kind of money with them. And we are unable to get the money back. So it is a very pathetic condition, my lords. When I was at the age of 50, I have booked this flat. Now I'm at the age of 65, 66. I'm bedridden. When will I get the money? There is no hopes, my lord, because there is no asset which is being auctioned or there is no action being taken by the state. That's how they are implementing in the state of Karnataka with respect to the top defaulter in the state of Karnataka with respect to RERA. This example, what they are setting, my lords, the state. So we need a quick implementation of this order. There are multiple contempt proceedings that are initiated already to the tune of almost 40 crores. And 100 families have already reached this honorable court. And there are multiple writ petitions that have been directing the state to implement these orders to the tune of 110 crores, my lords. But the state does not want to
Lords, we have
implement it.
implemented in the other contempt petition, my lords, we have filed our compliance affidavit wherein we have sold the properties and realized the money, my lords. Here also, we have attached quite a few properties, my lords, which I'll be filing the status report. It takes some days to implement the order by giving notification, calling for objections, all those procedures are involved, my lords. Lordship may grant me 4 weeks time, my lords. I'll file. As of now, we have attached about 10 survey numbers, my lords, in Devnalli Taluk.
My lords, let them share the documents with me and let them
File
it before.
I'll file the
honorable
status report.
Additional advocate, government advocate, Mrs. Pramodini Krishnan wants time to file the affidavit, stand over to 20th September as requested.
Please.
Lords, we seek implementation of the orders, my lords. Let it be.
Let us see what.
Please. We cooperate, my lords. Thank you.
Number
Lords,
32.
kindly notify respondent number 3 and 4 because they were dispensed with. That's where the assets are, which they are saying.
So only to 3 and 4.
3 and 4 also, because that was dispensed with.
All
Let them
the-
get the notices as well.
All. 3 and 4 to be directed to file reply.
Yes, my lords.
My lords, 4, my lords.
That's what is their request for
That
today.
is my request, my lords,
That is, but we have noted it.
because we'll be able to file the compliance affidavit.
And serial number 33 may also be listed on the same day, my lords. 73.
33.
73.
May I request this contempt petition be listed along with serial number 73, my lords?
And in serial number 70, my lords, not to bring the
One by-
73.
Who are 3 and 4?
My lords.
Who are 3 and 4?
3 and 4 are the Tahsildars, my lords, from the North District.
4 is the Tashildar Devnalli.
And 3 is the Deputy Commissioner, my lords.
My prayer is to not to dispense with notice to R4 because it is under their jurisdiction, the properties are available and we have attached.
Notice to all.
My lords, at serial number 73, the respondent number,
Then this all. Notice and
the
then.
respondent builder files a affidavit saying that they will pay us the money back. And court has also ordered them to pay 4 crore rupees. And it's been 6 months that they are not paying it. Till now, there is a court order alive in serial number 7.
After the reply comes.
Please, my lords.
Lordship may kindly tag this matter along with 73, my lords. It's a similar matter.
To be listed with 73. What is that 73? State appeal number 1335 of 20.
Contempt matter, 73.1 as well. Please. 73.1, contempt matter. CCC 909, bar 2023. There is a court order, my lords, wherein they have to pay us 4 crore rupees, and that's why it was posted for today.
Same day.
Please, my lords.
31. Of 73 with 31. So 31, 31, order passed, order to be dictated in 31. This contempt petition may be listed along with writ appeal number 1335 of 2023 and contempt petition number 8909 of 23.
Please, my lords.
It's number 32, waiting for the complainant. So Nagaraja, please.
Lords, in this matter today, the Special Deputy Commissioner has given permission to the Tahsildar to do the Khata, my lords. Today I have received the instructions. Some time may be granted.
Law and additional advocate Ms. Pramod Nikishan stated that the compliance of the directions of learned single judge is underway. Therefore, she prayed for time, stand over to.
Lords, may kindly take note of this letter, my lords. As per this
You
letter.
keep it, we record. Second of, we only with compliance. 2nd of 3rd of September. 2nd of September.
Okay,
So by that time you do whatever.
please.
This is number 33, so Jagdish Shastri.
I am per the complaint, Your Worship. Not complied by the respondent accused, Your Worship.
Well, it's on the last date also, we had stated that we're not the appointing authority. It's KPSC that's the authority, my lords. Kindly, if KPSC could be implemented to the matter, my lords.
Kindly see the order. Kindly see the order, my lord, passed by this honorable court.
My lords, I'd like to clarify, my lords, KPSC
number
makes the
34.
list of candidates. Based on the list of candidates, we have the appointing power, my lords.
Page number 34.
The directions are in your favor.
Yes, ma'am, my favor, ma'am.
What is the difficulty?
Difficulty is, my lord, they have to appoint me, my lord. He is the appointing authority. My lord, I produce, my lord, may I produce, my lord, the appointing, he is the appointing, but he is saying lie before the court, my lord, he is not appointing, but he is the appointing authority. Other candidates appointed, my lord, the same notification.
Then you have to, by this other, someone else is appointed. By this notification, somebody else is appointed.
Yes, Lordship.
Then you have to challenge that appointment.
Yeah, they have to appoint to me, but they are not appointing, Lordship.
So instead of.
Instead of
pursuing
saying
this-
that, like, yes, sir, same, Lordship. Instead of appointing me. Let's see, that is in Kannada, Lordship. Kindly see.
But for the specially
Annexure B, Lordship.
abled person, the quota is not there.
Blood?
You are a differently abled person.
No, I'm the different able person, but I'm eligible for general merit candidate. GM category. I'm eligible for GM category, so court has directed to select on that GM category and give the appointment. Lordship. Page number 34. That is cost that the endorsement has cost, my lord. After the costing of endorsement, court has directed third responder to appoint the petitionership. Order is passed on, my lord, 18th November 2023. 18th November 2023, Lordship. Annexure A. Lord, kindly see page number 34. Clear cut direction is there. Third responder to appoint the.
My lords, I'd like to clarify, my lords, KPSC, which is respondent number 2 in the original writ petition, has the power to make the list of candidates.
The selection is to happen place. He has to be included in the selection list. The grievance was not selected. Take instance.
My lords, KPSC is to be implemented in this matter, my lord. We cannot go outside the scope of the list of candidates that they have provided, my lords.
What is the role of KPS?
My lords,
What is the role of newly added party?
my lords, based on the list that KPSC provides, we can appoint of the candidates that are provided in that list, my lords. Hence, we are
163(1) doesn't say that you can say blanket the entire cabinet disabled because the chief minister is involved and he appointed.
Join.
Milord, in this case, there is no direction to the KPSC, so made a party. Direction to the third respondent, in the petition, he is in the petition, KPSC's party. But there is no direction to the KPSC to appoint me. The direction is only to the third respondent. Third respondent is the appointing authority. Kindly see the cost title after.
my lords, the appointment can only be done.
They are contested in the before the single judge, KPSC and the third respondent.
My lords, the appointment can only be done based on the list that KPSC has provided us, my lords. Hence, we are
Their
asking
internal
for KPSC.
communication, not that.
Hence, we are asking for KPSC to be implemented in this matter.
That is internal. KPSC is a party earlier.
My lords, KPSC is a selecting authority in this matter, my lords.
Two things I've done here.
KPSC is the selection authority in this matter, my lords. Based on the selection authorities list, only we can proceed, my lords. Hence, we're asking for KPSC to be implemented in this matter.
So he is not selected.
My lords, his name is not reflected on the list, my lords.
Milord, they are selected in the page number. May I put it? KPSC is selected. Milord, this is selected by the KPSC and it is serial number 14. And the same thing is third respondent. That is, my name is reflected on the selection list, Your Worship. That is selection list at serial number 14. I am the selected candidate in the GM category, Your Worship. GM PH category. After selection, Lord.
116, 118.
The list was sent to the KPS, the third respondent, and third respondent reject my appointment. After I approached the Honorable High Court, and Honorable High Court had directed to the KPSC, to the accused number 3 to appoint me. Actually.
Exactly the point. There was a case where governor had to act or was required to act on the aid and advisory council of ministers because he is not acting on his own. Now here is a case where sanction has to be accorded by him acting on his own with application of mind is imperative. Yes, that you may say. Very well. I will according this judgment may not be. No, I'm only saying Nabam Rebia and MP will be considered a final hearing in some form as to
There is no appeal filed against this.
No, my lords.
What is this memo?
Lord, that is the appointing, and that is he has last time submitted that he is not appointing authority. I am given the memo in respect of he is appointing authority. That produce a record, sir.
Record of somebody else.
Somebody similar notification after. He has appointed other candidates. Annexure B, I produce B, Annexure B. There are candidates where they are appointed by the accused, Worship. In the first line itself, it shows that Nemkati Pradhikara.
So notice is already issued. Who is for number 3?
My lords,
This one was 3, you are appearing, Karnataka Residential Education.
Yes.
yes, my lords, so applying for Karnataka residential
Why
education.
don't you not, why are you not complying with this direction? Appoint the petitioner by considering the petitioner as a candidate under general merit category.
My lords, the instructions that we've been given is that we cannot appoint it is based on the selection authority that we can appoint, my lords.
Lord,
Hence,
there is-
on the previous date, we had made a submission that we are not the appointing authority and for KPSC to be impleted, my lords.
Similar, he is saying that he is not appointing, he is appointing authority. Therefore, I produced the notification Lordship. Earlier, my lord, that is he is misleading to clear cut this court.
My lords, KPSC is also is the party in the writ petition, my lord, but has not been arraigned as an accused in the current matter.
What is the problem?
Lord, I am the question of livelihood, my lord. I am the candidate, GM merit is candidates, my lord. There is a direction, clear cut direction to the third respondent to appoint. There is if a direction to the second respondent, I will made a party, but there is no direction to the KPSC. Lordship.
Why you are not complying?
My lord, they have to comply, my lord. This is the duty of the third respondent, accused, Lordship. Accused has to comply, Lordship. Third respondent, he is the party, my lord. Now he is before the court. But he is saying misleading, I am not appointing authority. He is appointing authority. Accused number 3, my lord, Karnataka Residence School. Karnataka Residence School, Lordship. Undertake government, my lord. He is undertake government. He is the respondent. He before the single judge, my lord. He is the accused now. He has to appoint me, Lordship.
On 30th.
Lordship.
I am not able to catch what you are saying.
My lord, this is not complied by their respondent is not complying the order of the single bench, Lordship. Single bench has ordered, my lord, to appoint the petitioner, my lord, complainant. My lord, the order is, my lord, against the accused number 3, Lordship. Here, Lordship. Kindly say, respondent number 3 is directed to appoint the petitioner by considering the petitioner as a candidate under the general merit category. Necessary order shall be passed within 1 month from the date of receipt of this order, Lordship. My lord, the order passed on 18th November 2023. There is a party, my lord, selection is the authority KPSC and appointing authority is the CRIS, my lord, third respondent. And this court is directed to third respondent to appoint the petitioner. Earlier, the second respondent has selected me and sent the list to the third respondent. Third respondent rejected, and therefore they issued me endorsement. That endorsement quashed by this honorable court annexure, my lord, kindly see page number 34. That quashed and directed to the third respondent to appoint me.
30th.
Lordship.
This is contempt.
Yes, Lordship, contempt petition this is.
My lords, if a short accommodation could be taken, my
No.
lord, seek instruction. My lords, the instructions.
You are not complying.
My lords, the instruction that we've been given is that KPSC has to be implemented in this matter, my lords. Without their authority, we cannot proceed, my lords.
Every time he is submitting paper, he is not appointing. Though I produced the records, if he is appointing similar notifications, same other candidates are appointed by him. Now he is saying, I am not appointing authority. Clear cut misleading before the court worship. I given the note, list worship, we are appointed by the third respondent.
This can be resolved. Refusal to wait. Inspection of they have to read our book. Or they have to seek either one of them has to seek clarification. Because it cannot be given them. Are you selected?
Yes, Lordship, I am selected. Therefore, I produce annexure, Lord, on another notification at serial number 14.
Respondent number 3 is directed to appoint the petitioner by considering the petitioner as a candidate under the general merit category. So you want appointment?
Yes, Lordship.
So there is no selection of yours.
Lordship,
You are not selected.
I am selected. Therefore, they issued endorsement. That endorsement challenge before the court. And the endorsement is quashed. And after that quashing of endorsement, the court has passed directed order. Lordship.
Now, what is the contempt today?
Now contempt is not, they have to appoint, they are not appointed me, Lordship. They are not appointing, Lordship. Third responding not appointing me. That is a contempt.
Rule written level 1.
Lordship.
Rule it we finally. You convince on that. 14.
Well, this livelihood question is a question of livelihood, my lord. Petitioners, my lord, respondent accused is asked to implement the court order, Lordship.
But then the counseling saying that you implement the particular authority.
Lord.
The section authority, my lord.
There is no direction to the court of this implement. How it is necessary, Lordship?
It is not implemented. How can the court will?
The court is direction only to third respondent to appoint. There.
Not implementable because that is not the competent authority. That is what the council is saying.
No, that is wrong, Lord. That's why I'm saying that he is wrong.
Wrong, then we are also wrong.
Kindly see third respondent is the accused, Lordship. Third respondent, clear cut direct against the third respondent. Here, my lord, kindly
If you want compliance of the order, you can't be that adamant.
My lord.
If you want the order to be complied with, it should be complied with by a proper authority.
My lord, that's why earlier, my lord, but I selected.
Have you filed your reply?
Not filed, Lordship.
My lords,
Your reply is filed?
my lords.
File it. Let the reply be filed by the respondent. Stand over to September 19.
My lord, too much, my lord. This going on. I filed, my lord, in the 3rd of May 2024. I filed, my lordship.
So you want
different? There is a direction only within 1 month they have to appoint me.
You want another date?
Earlier date, lordship.
22nd October.
Lordship, what is this, lordship? If it is, I'm seeking come before court, getting justice, lordship. If the court is adjourning same day, what is possible? Not for me only. I mean, this is a question of livelihood, lordship. If doing court is like this, where should go, sir? Client where should go, lordship?
We are asking them to file reply.
But they are they're taken several times, lordship. They are taken earlier, kindly see taken several times, they are not filed affidavit, lordship.
Then you will rescind the order and don't speak about.
My lord.
It is final. You are inviting order.
My lord, leave it to court, lordship. I will leave it to court, lordship.
If you are leaving to the court, so we are directing them to file a reply.
Earlier, that's why give the give the next week, lordship. That is a requesting, my lord.
Pardon?
My lord, give the earlier date, lordship. That's why.
Earlier date, all right, tomorrow.
Yes.
10 to tomorrow as requested by Lord.
2:30.
Be reasonable, Mr. Council.
In reasonable, Your Worship.
What is the nonsense this going on?
No, my lord, I'm-
Unnecessarily wasting the
reasonable
time
time,
of
Your Worship. Reasonable opportunity should be given, Your Worship. That's, I'm not seeking tomorrow, Your Worship. Reasonable, Your Worship. Not long, my lord.
Again, you are continuing like anything.
Sorry,
We
Your
are
Worship.
not going to change our order.
Sorry, Your Worship.
I am as good as you. In adamancy. Yes. 19 September, 10 to 19 September. Before that, the reply shall be filed. Reply will be filed.
Please, my lords.
And you consider joining the proper party if you want real compliance. Otherwise, again, we'll be back to square one.
The court is direction not to against the third respondent,
Very
second
good.
respondent.
You
If
file.
it is
34.
the internal communication between them, the selection authority is the selection, authority, they have to communicate and they have to file the before the court appeal or revision, Your Worship. But only direction to me only to appoint. Here once again you have to go to prolonging, Your Worship. That is the reason.
Will not prolong.
34. Paper three.
That's, this government has issued an order to file writ appeal, my lords. Time may be granted.
Writ appeal is filed.
We have to file, my lords. We have
The
just
order was
received the
passed.
order.
Order passed on 7/11/23, my lord.
What is the direction?
For date of the 7th of November. Within 3 months, he has to comply this order, my lord. Page number 32, my lord. Permission. Friendly.
This is what? This is only deciding representation.
Lords, there is a direction to restore the name of the petitioner in RTC, respect of the land, so and so.
Land was granted, my
Page
lord.
number 32, my lords.
32, my lord.
32, my-
32.
Last
paragraph.
Accordingly, impugned endorsement dated 19/6/23 issued by the respondent number is set aside. Respondent 2 and 4 are directed to restore the name of the petitioner RTC extract in respect of land bearing the survey number 39. In extent of 4 acres, 31 gunta situated at Kolangi, Abdul Village, Malipatna Obli, Atul Road, Asan district. Within 3 months from the date of this order. What happened, the endorsement issued on page number 24, annexes D.
This land has been forfeited to the government in way
Not
back in
forfeited,
19
even I am in possession of the property.
1933 itself, my lords.
I am in possession till today. What happens earlier?
Order and direction of learned single judge sought to be complied with in this contempt petition was passed as back as on 7th November 2023. Full stop. The relevant directions read as under. Page 31 bracketed portion accordingly. Impugned endorsement dated so and so set aside was like a receipt of the order. Full stop. Today, when the contempt proceedings come up for consideration, learned additional advocate, Mr. Pramodini Kishan submitted that the state government has now decided to file appeal against the aforesaid order. Full stop. The order according sanction to prefer the appeal was produced, which is dated 9th of August. 26th of July, 2024. Full stop. It is after 1 year that the state government has decided to refer the appeal. In the meantime, the order of the court has remained uncomplied with. Full stop. This depicts very sorry state of affairs and it is deprecated. Full stop. It is directed that if the writ appeal is to be filed by the state, the same shall be filed immediately and within 10 weeks from today, within 8 weeks from today, if any orders, if approved orders are not obtained, the directions shall be complied with within 1 week. That is in the 9th week. Full stop. Failure on this count will expose the respondent to an aggravated form of contempt. 10 to 26th September on which 24th September on which date? 24th September.
Number 35. Jagdish Rema.
Yes, my lord, the direction under this order to pay rupees 30,000 to the wife and two minor daughters per month from August 2023, my lord. My lord, I'm regularly being paying to the said amount to my wife and children. I filed the counter on 17th last Saturday, my lord. It is not been put up. My lord, the order is at page number 9, my lord, impugned order.
Page number
9, my lord.
9.
9, ordered. Order in penal petition number
Directions,
9.
Page number 16.
Page number first, page number 9, my lord. High Court order. 60, I don't have regular papers, my lord. Page number 9 is the order, that is a complaints order, that there is an order to pay 30,000. Towards maintenance.
15. It is good. So your wife,
Wife and two daughters.
who have
For accused.
it is fresh.
Yes, file complaint matter.
It is fresh.
Fresh matter is.
Notice returnable on
No, my
18th of September.
No, I am for accused, my lord. Notice is order.
Who were for accused?
Yes, my lord.
So paid.
I have complained, I have filed the counter on Saturday, my lord, 17th August. And I'm being regularly paying the said amount to my wife and children. I have a statement.
Well, let them come. Learned advocate for the complainant was not absent, was not present in view of. In that view, stand over to 18th of September.
Number 36. Onkar Indi.
Represent the complaints, my lord.
Lord, I'm for the respondent accused, my lord.
Reply is not filed so far, my lord.
Lord, and
Reply is
complaints
not
of my
filed
lord,
by them.
in complaints of the order of the learned single judge, my lord, and endorsement, my lord, has been issued on my lord 17/8 by my lord RPD, my lord. I'll file complaints report, my lord, on the next date of hearing. It's been issued. Complaints, my lord, and complaints of the order of the learned single judge, my lord, an endorsement has been issued saying that, my lord, the amount of compensation for the acquisition of the land for the metro project that cannot be, my lord, paid because, my lord, there is, my lord, the BMRCL has challenged the order of the assistant commissioner before the deputy commissioner, that is pending, my lord, adjudication before the deputy commissioner. So, my lord, it cannot be paid. An endorsement, my lord, came to be, my lord, issued on 17, my lord, 8. I'll file complaints report, my lord, next week, my lord.
They themselves have undertaken before the learned single judge, my lord. I should kindly say, in page number 12 of the impugned order, that is the order passed by the single judge. Para 4 of the order, my lord. The
Not-
learned counsel,
why you are not
respondent
deposited
2 and
the
3, yes, they themselves are undertaken.
You have not deposited the compensation.
They are not complied so
Lord,
far,
it's a
my lord.
government land, my lord. It's a government land.
Whatever it
Whatever
is,
it may be,
why
they
you
are
are not
under-
Lord, we
deposited?
have paid the compensation for the structure, for the building. So far as, my lord, land is concerned, my lord, the land belongs to the government.
Then you
Lord,
challenge this order.
that, my lord, we have given, my lord, endorsement saying that, my lord, it belongs to the government. We have considered his representation, my lord, endorsement has been issued. He has to challenge it, my lord.
They themselves have undertaken that they will deposit before the reference court within 3 months.
What is the amount of compensation?
Compound award, they have not yet decided, but they have undertaken that they will deposit the amount before the reference court. Because there is some dispute with the ownership, my lord, they have undertaken that they will deposit before the reference court within 3 months.
We have paid 19,70,513, my lord,
It is
so
not
far as
the
structure is
question
concerned.
here.
So who will deposit number 2?
Number 2, by BMRCL has to, my lord,
Sir, you deposit or be here in person?
my lord, BMRCL, my lord, he has not made party, my lord, the BMRCL, my lord,
We don't know.
they have to send, my lord.
You are appearing for whom?
I am for the KDB, my lord.
Hmm?
I am for the Karnataka Industrial Development Board, my lord. Respondent number. Respond number 2, my lords.
2, huh?
No, respond number 2. My lord, the writ petition, my lord, BMRCL was also party, my lord. They have to send package to the, my lord, the respond number 2. KDB, then only, my lord, my lord, will pass, my lord, award and deposit it.
Who is your special land acquisition?
Special and acquisition officer, my lord, is acquiring authority for the purposes of, my lord.
Who appeared?
I appear, my lord.
You are appearing.
Please.
Let him be here. Respondent 3, are there a deposit the compensation within 3 weeks or will hold him for contempt? There is a clear direction to deposit. You deposit.
They have themselves undertaken, my lord.
There can't be any argument on merits here in contempt proceeding. Isn't it?
Yes, correct. 2 weeks time may be granted, my lord.
We'll grant 3 weeks.
Please.
Full stop. The direction in the order of learned single judge is to respond to 3, the special land against officer to deposit the compensation amount before the reference court within 3 months. Full stop. This direction, all the more, is based on the concession given and readiness shown by the very authority to deposit the amount. Full stop. The non-compliance thereof has given rise to the present contempt proceedings. Full stop. While adjourning the proceedings at the request of learned advocate Mr. So and so for the respondents, including respondent 3, it is provided that unless the directions are complied with by depositing the compensation amount before the reference court within 3 weeks, it is provided that while granting time, it is provided that respondent 3 shall personally remain present on the next date of hearing to explain the conduct of non-deposited amount with clarification, however, that if the amount is deposited as per the direction within 3 weeks from today, the presence of respondent 3 will not be necessary. Full stop. Stand over to. Today is what? Today is 20th. Stand over to 19th September.
Please.
Much up.
It's number 37. Ashwini.
For the complainants, my lords, the complainants upon completing their 3-year LLB degree, they approached the accused to enroll into the State Bar Council. However, finding the prescribed fee exorbitant and contrary to the provisions of the Advocates Act, they filed a writ petition before this honorable court. And this honorable court was pleased to pass an interim order on 9th May of this year, directing the accused to enroll the complainants, subject to them giving an undertaking that they would pay the prescribed fee as decided by this honorable court finally, or as decided by the Supreme Court in a similar matter in writ petition 352 of 2023, my lords. However, after this interim order, they have been issued emergent notice, and the notice has been served on them, and 3 representations have been made by the complainants on 14th May, on 31st May.
You appeared in the You're enrolled or not enrolled?
Not yet, my lords. Then refusing to enroll the complainants.
May I submit? The issue pertains to notes of fixation of enrollment fee. Notes, the petition notes are filed notes and the interim order was granted upon. Notes may kindly see the last order. It says, subject to result of notes Supreme Court order in the writ petition number 352 of 2023. Now, this writ petition notes has been disposed of notes on 30th of July 2023. 24 notes. Where is not the Honorable Supreme Court notes has fixed up the fee, enrollment fee. Notes for general merit category notes to an extent of 750 rupees and notes for SC/ST notes it is 125 rupees. Therefore, notes in view of the order notes being passed by the Supreme Court, notes this notes the contempt petition does not survive a consideration because now we are bound by the notes order being passed by the Honorable Supreme Court. With respect to notes fixation of enrollment fees concerned.
You're supposed to enroll the petitioners.
Subject to result of the writ petition order being
My lord,
passed in
it
writ petition.
says subject to the decision or either of the High Court or of the Supreme Court.
Now, Supreme Court has
Have
passed.
not complied with the order.
The order of Supreme.
This honorable.
Well, I just provide notes. I just.
What is the order?
Order says Supreme Court has fixed the enrollment fee for an advocate note for general category notes. It is worth 750 rupees, and not for SC/ST notes it is 125 rupees. Now, milords, we have to follow this order of the Supreme Court. Now, meeting will be conducted by the Bar Council of India with respect to milords how to implement these particular orders, and milords subject accordingly. Milords will proceed for enrollment of the same.
But then you enroll. Enrollment is.
We have to, milord. We have to, milord. We knew of the order being passed the Supreme Court. It says subject to result of an order being passed by the Supreme Court. Now, on 30th of July, milords, the Supreme Court has passed an order by fixing the enrollment fee. Now, milords, we are bound by the milords order being passed by the Honorable Supreme Court.
You are bound by the fees, but what about enrollment?
Accordingly, milords will fix up. Accordingly, milords will fix up. Accordingly, milords will fix up a date for enrollment because there are other issues.
My
I
lords,
think that they will start enrolling.
Please,
we have to do it as soon as possible, my lords, because it's affecting the livelihood of my clients, my lord. They waited for so long. For 9/5 was the date of the order, interim order of this honorable court, and since then they have been declining to enroll them.
But hearing was taking place not before Honorable Supreme Court. That's the reason milords we waited for it. And milords now in view of the order being passed by the Honorable Supreme Court, we are bound by it. Accordingly, milords, now we have fix up a date for enrollment.
You produce the Supreme Court order.
I'll produce it. I'll produce it.
Fine. Day after tomorrow.
Day after tomorrow.
Day after tomorrow at 2:30.
Please.
Number 38, Satish K.
Here for the complaint. The order is at plot page 13. But the relevant portion is at plot page 21. But without holding any inquiry, my lord, the service of the complaint was terminated. But termination was called in question before this honorable court. But this honorable court allowed the petition and directed the respondent to reinstate with all consequential benefits. Page 21, Lord.
Who appears?
Mr. Keshav Murthy CN.
So notice is issued or not?
Notice is issued.
Notice is
served.
where-
I'm not
Not getting the notice.
Lord, the order, my lord's order is at on 27/6/2024. Date was given as, my lord, 19/7.
Who appears? Nobody appears.
Keshav Murthy.
South. South. Day after at 2:30. The matter could not proceed in view that the presence of learned advocate for the respondent was awaited in vain. Full stop. Stand over to 21st at 2:30.
Number 39.
Sublime.
Shri Srinivas K.
My lord, I appear for the complainant in this case. Matter pertains to Lord appointment and compassionate ground, wherein there was a direction in February 2024, my lord, for appointment of the complainant to a suitable post on compassionate ground within a period of 2 months. Annexure D, my lord, is the order passed in the writ petition.
Lord.
Till
this
date, my
matter-
lord, they have not taken any positive steps, my lord, in this regard. And similar cases, they've already appointed the other employees, the legal heads of the deceased employees.
You are for
But
My lord, I am for the accused, my lord, this matter, my lord.
which respondent?
Sorry,
Which respondent?
Lord, I appear for A2 to A4, my lord. Accused number 2 to 4, my lord.
That is BESCOM.
Yes, ma'am. Let's go. Lord, writ appeal has been filed, my lord, challenging.
What is BESCOM? Electricity company.
Yes, ma'am, electricity company.
fourth, accused number 4, my lord, is the authority who had issued the endorsement, and that has been set aside by the Sambo court in the writ petition. And direction was issued to consider the case of the complainant for appointment on compassionate ground.
Lord, writ appeal has been filed, my lord, challenging that order.
Rita Police.
Yes, ma'am.
It was stated
Writ
by
up-
learned advocate.
They have not obtained any stay, my lord, so far. It is
Request.
merely filing of writ appeal, my lord, will not absolve the, my lord, accused.
Respondent BOSCOM that the writ appeal is filed against the order brought under the contempt jurisdiction. Therefore, it is already filed.
Yes, ma'am. It's already been filed, my lord. It's been-
Therefore, the hearing of the present petition may be deferred. On the other hand, learned advocate so and so stated that mere filing of writ petition is no answer, not to comply with the directions. Paragraph, since the appeal is filed, it will be proper to permit the appellant respondent herein to contest the appeal on merits. Therefore, this contempt petition may be listed with writ appeal number so and so on 18th of September. Or say earlier, little earlier, 6th,
18th of September.
3rd of September.
Much obliged.
Obliged.
Number 40. Anil Kumar.
I appear for the petitioner.
You were the respondent accused in this matter. In this matter, I've instructed your lordship that the list has been redone, the seniority list has been redone. And it's a bulky document, yes. A week's time may be granted, we will.
Learned additional advocate, the additional government advocate, Mr. Jafar Shah wants time. Stand over to 17th of September.
Number 41. Mr. Satish K.
Lord, I appear for the complainant.
Order has been complied with, my lord. Endorsement is communicated and I may be permitted to file a copy of it.
Just about, my lord, a minute ago, my lord, I have been served with my lord, order of appointment. But the endorsement issued on 14/8. And as my lord, I may be permitted to, my lord, look into the my lord, appointment. Just about 1 minute ago, my lord, it is served.
There was a direction, my lord, that I should consider his representation for appointment.
Learned advocate, Mr. Swans, files the compliance affidavit, which is taken on record, in which it is entirely contended that the order is complied with and the necessary endorsement is issued. On the other hand, learned advocate, Mr. Swans, wants time, stating that the compliance affidavit is received just before. Stand over to 23rd of August, to be listed at 2/3. Twenty-second August,
Yes.
22nd.
It's about 42.
In this, my lord, I have to implement the order of the Honorable Supreme Court, my lord. I may require another 15 days time, my lord.
42.
42, my lord.
1 submission. 10 years, my lord, we have been fighting for the last 10 years, my lord. On
It was-
27/6, they have taken time to comply with. Page number 125 is the order of the Honorable Supreme Court originated in 2014, 125.
Direction, my lord, is to evaluate as to each of these, whether each of these persons are entitled to an additional 2%, my lord, of pay, my lord, based on the criteria to be fixed. That process is on, my lord. I will be able to complete it.
In fact, they have taken a decision as per annexure, my lord, K, page 185.
Direction, time frame.
It has been confined only to the petitioners. Totally 32%, 32. Totally 32 persons, employees, my lord, it has been confined. On 27/6, my learned senior friend submitted that they are going to comply.
We are in the process, my lord, will, although there is no specific time frame, my lord, fixed by the Honorable Supreme Court, my lord, to complete the process. We are at the fag end of it, my lord, will.
2014, not some.
Supreme Court's order, my lord, directions are at
Page
page 124. Paragraph 4. This
Payment-
modifies the, sets aside, my lord, the order of the Honorable Court, my lord, and gives directions that there has to be a process of evaluation based on the criteria to be fixed.
For the last 10 years, we have been fighting, my lord. Only that much request I can.
When will you do that?
Not 15, 20 days, my lord, I should be able to complete the process. The only difficulty, my lord, was because this pertains to, my lord, as he is saying, my lord, a long period was involved. We had to collect data, my lord, from all over the state. And that took some time, my lord. Some data was not available.
Otherwise, respondents may be, Lord.
We simply at the request of Lord and Advocate Mr. So-and-so, send over to 19th of September.
Right.
Within which time it was stated that the
2:30 minutes.
substantial steps will be taken in complying with the direction.
Grateful. Yes.
2:30 minutes. Please.
Symbol 43.
My lord, I'm appearing for respondent number 5, my lord. I'm appearing for respondent number 5, my lord, KPSC, my lord.
Here for the petitioner in 43. 43 is filed challenging the amendment to the conditions of supply of electricity, where they have removed the requirement of producing a sanction plan or an occupancy certificate prior to obtaining an electricity connection. 43.1, my lords, is a suo motu petition that is initiated by this honorable court, taking notice of the failure of the state to take action against unauthorized and illegal construction. When this court is inquiring as to how the state is not taking action against unauthorized construction, another arm of the state can't say, you come and apply for an electricity connection, I'll give it to you irrespective of whether your construction is illegal or legal.
My lord, I'm appearing on behalf of the amicus in 43.1, my lord. The senior counsel is not keeping well. So kindly adjourn the matter for 2 weeks.
The respondents in 43 may be directed to file their objections. Matter has been pending for a year and a half now.
Who appear?
I appear for the government in this matter. He'll file this.
You have to file reply.
Yes.
Do it.
or to BBMP.
Last day.
So the requirement of furnishing the occupancy certificate and the
Sanction plan has been removed.
is deleted.
Is deleted prior to seeking an electricity connection. Therefore, that means if I have an illegal construction today under municipal law, under the BBMP Act and the Karnataka Municipal Corporations Act, I can't occupy that premises in the absence of either a sanction plan or an occupancy certificate. But I can get an electricity connection for those premises. In fact, this honorable court in 43.1 has passed numerous orders noting how this affects the fundamental rights of every other citizen because it leads to unplanned death.
43.1, Your Lordship. On the last date of hearing, the BBMP had made an submission that there is a shortage of engine.
My lords, in 43.1, which is a suo motu petition, my lords, the KPSU is supposed to file their objections for not having processed the recruitment process for recruiting assistant engineers, my lords.
My lord, I have one submission, my lord. Now the applications, the examination is scheduled on 14th, 15th September 2024 for candidates of RPC, my lord. And the examination is scheduled on 19th, 28th of October 2024 for candidates of Hyderabad, Karnataka, my lord. Process is going on, my lord. We are going to appoint, my lord, in the next September and October, my lord. Notification has been issued.
So they can give, you can give connection at every place, any place, irrespective of no occupancy certificate, no identification.
That is the challenge we have made. It cannot be in the absence.
Then what makes it? You can take it and registry for the certificate. As per the plan. Without waiting for the electricity.
Your Lordship.
Where is that regulation?
Karnataka.
Let me see annexure M filed along with my petition. It's filed on 1/3/24 annexure M.
Page 45.
Page 45, 43 it starts at annexure M along with my amendment application. Let me see page 61.
51.
61.
61.
61. Amendment to certain clauses, my lords have. 2.13, previously it used to say, built up area means the sum of building areas on the floor, including the cellar, measured between external walls as per actual construction or as per sanction plan. On the right-hand side is the regulation that is amended. The reference to a sanction plan is removed. My lord, me see the next page, 62. Regulation 9.01. This talks about the regulation 9.01 on page 62, my lords. Talks about the documents to be produced at the time of seeking a fresh electricity connection. On the left-hand side, 9.01, the first one is a copy of sanction plan of the building. On the right-hand side, it just says copy of plan of the building. The problem is this, today in Bangalore, there are n number of illegal unauthorized constructions where no occupancy certificate is there, where there is a huge amount of deviation from the sanction plan. This court has noticed that it is a menace. In the meantime, if the electricity supply companies are granting electricity connection to further constructions that are unauthorized and illegal, it is just mushrooming of the problem. In fact, this honorable court in 43.1, my lord.
No, this page 61.
My lord, can I make a submission here?
Page 61 doesn't indicate anything.
My lord, can I make a submission here?
Page 61 doesn't indicate anything.
62, my lord.
62.
Please. Regulation 9.01 on the bottom left-hand side. Previously, it used to say owner, promoter or occupier of multi-story building or complexes shall register application for power supply in the prescribed form along with the following documents at the jurisdictional subdivision office of the licensee, duly paying registration cum processing fees as per clause 30.01. The very first one is copy of sanction plan of the building or complex showing built up area of the building. My lords may now see the column on the right-hand side, which is the amended provision. Copy of sanction plan has been just changed to copy of plan of the building complex. Then my lords may see page 63. Small Roman numeral 3. In fact, over here, previous to the amendment, it says in case the applicant fails to produce the plan of the building or complex duly showing built up area of the entire building, the application shall be rejected. On the right hand side, that has been deleted. In 43.1, my lords, this honorable court has passed an order on 19th of September 2019. Saying that illegal and unauthorized constructions in the name of compassion and hardship should not be tolerated. If the electricity supply commissions are giving electricity connections to all such illegal and unauthorized constructions, my lords will have a batch of PIL petitioners before my lords saying that, but I have been given electricity connection, you cannot demolish my building. In fact, this honorable court has looked at a entire batch of Supreme Court judgments that talk about how there is a fundamental right to planned construction in the city. And how unauthorized construction, unplanned development will actually affect the fundamental right of the other citizens.
So you are challenging 2.13. What is 2.13?
Please.
My lord, can I make a small submission here?
Let this.
No, on the same topic, on the same point.
Where is 2.13?
2.13, my lords, is at page 61, which I just read out along with my amendment application.
What was that?
That was the one that defined what built up areas and removed the reference to sanctioned plan to make it just plan. Then my lords have also challenged the amendment.
So built up area provision was taken out.
Please. No, built up area was previously defined as built up area as shown in the sanctioned plan. Now it is defined as just built up area in the plan.
Oh,
Then my lords, I'm also challenging the amendment to 9.01.
And third is 10.1.
Please.
Which is that?
10.1, 10.01, my lords, is for industrial loans, mixed loans. Over there also sanction plan requirement has been removed. There, in fact, previously it was a layout plan approved by the competent authority. My lords, may see page 63, 10.01.
Page 63.
Page 63.
Bottom.
10.01.
Yes.
Previously, it said on the left-hand side, application along with a layout plan approved by the competent authority. Now, let me now see on the right-hand side, it just says application along with a plan of the layout. Therefore, it says even for a layout, electricity can be supplied without even awaiting a layout plan that is approved by the competent authority.
Where are the actual provisions?
The left side.
Same.
The left side is the unamended. The left side column is the unamended provision.
Actual means these are actual or this is a description?
These are the actual provisions. The conditions.
In the same language.
Please, ma'am.
So you have lifted from the statute itself.
Please, ma'am.
Is the application
statute
along
gives
with
them-
layout plan approved by the competent authority duly shown is a part of the.
Statute, my lords, gives the power to the respondent number 2 to frame these rules.
Gazette.
This is gazetted, my lords. My lords, we
So-
put that on page
This is
57.
if I may clarify, your lord. This is the order of the Karnataka Electricity Regulatory Commission, your lord.
Now, what is the logic of this?
This, what?
No, it's totally illogical.
No, no.
And
I will.
it is an invitation to several evils.
No, my lord. Lordship, this is with regards to multi-storied building and commercial apartments. Primarily, what my learned friend said was mushrooming of all the building. The basic requirement for an EWS and middle class constructions, because 30, 40, 20 by 30, 30 by 40 and up to 60, 40, which is considered as residential dwelling houses. For those ends, occupation certificate is not mandatory to obtain an electricity connection. That is the rule of the ESCOMs. Now, what had happened is, Your Lordship, my learned friend has, mixed up the entire matter, saying that 43.1 and 43. 43, the Sumoto construction, where it said illegal construction, that is the violation of the sanction plan, where the entire role has to be played by the BBMP. BBMP on last date of hearing has made a submission that there was a shortage of staff. And as per the directions of this honorable court, the KPSC was made a party before this court. And one of my learned friend is appearing for the KPSC, just submitted that the exams are scheduled for appointment of the assistant executive. There are about 2.5 lakh buildings that has to be surveyed on an individual basis to identify the violation in construction. That is the first aspect in the Sumoto case, that is 43.1. The other 43.1, Your Lordship, serial number 43.1, where my learned friend said the Sumoto cognizance was taken by this honorable court, is for the illegal constructions that have been prevailing in the Bangalore city, where people have violated the terms of the sanction plan overall. For that, Your Lordship, the regulatory authority is the BBMP. BBMP is the town planning authority who sanctions the plan, Your Lordship. Now, BBMP has submitted before this court saying that they will survey the entire buildings in Bangalore city and submit before this honorable court. However, there was a shortage of staff, and for that,
When the notice was issued?
This matter, my lords, notice was issued in November of 2022. in
22?
43.
22.
They have
When you are going to file affidavit? The petition is a citizens action forum. The prayer in this public interest petition is to strike down
like KPSC notice was issued.
The amendment in the conditions of supply of electricity of distribution licenses in the state of Karnataka, into COS, C capital, O small, S capital, bracket over, second bracket, 10th amendment, bracket over, 2022. Notified by respond number 2, Karnataka Electricity Regulatory Commission as arbitrary. It is prayed to strike down the also to strike down the conditions of supply of electricity of distribution licenses in the state of Karnataka into COS 11th amendment 2023. And the Karnataka Electricity Regulatory Commission into recovery of expenditure for supply of electricity into 12th amendment regulation 2023, notified by the commission insofar as the amendment made in clauses number 2.13, 9.01 and 10.01 of the conditions of supply. Why you are challenging all these amendment 3?
Please, ma'am. By the 10th amendment, they had removed the requirement of producing an occupancy certificate. By the 11th amendment, they have removed the requirement of producing a sanction plan. The 3 different clauses I have challenged are one clause where you're obtaining at the time of a fresh electricity connection for a multi-storied building. The next is for an industrial or a mixed-use building. My learned friend had said that for a 30-40 site, it is not necessary, but that is not the purport of this rules. For a 30-40 site, an occupancy certificate may not be necessary, but that is not what the COS says.
So 2.13 was amended by 10th amendment. 9.01 by 11th.
By 10th and 11th.
And 10.1 by 12th.
Please. 9.07 was amended by the 10th amendment. If I may, my lord, by the 10th amendment, I have challenged the amendment to 9.07. That is at page 44 of my petition itself.
By three aforesaid amendments, namely 10th, 11th and 12th, for different provisions are inserted in the conditions of supply regulations. Notification dated 11/1/23, proposing the notification dated 11/1/23 issued by the Karnataka paragraph Electricity Regulatory Commission, notifying the said three amendments, figures on record. The amendment in the aforesaid clauses are indicated. The following chart, the following tabular form would go to show the original regulation and the amended regulation. So 3 will be there. This 2.13, original this, amended this, at page 61. Then 9.1, original this, serial number 4, and amended uske samne pura. Then 10.1, serial number 5, page 63, original this and amended this. The paragraph, learned advocate Miss
Nitya, NITY.
so and so for the petitioner submitted that the not that before that, as per amendment in clause 2.3, the requirement of the built up the definition of built up area is modified by taking out the word sanctioned, and which will have the effect that while supplying that while giving the electricity connection, the plan of the premises may not be sanctioned, but on mere production of simple plan, the electricity authority would make available the connection at the premises. In the same way, by amending clause 9.01, the requirement of production of occupancy certificate by the owner, promoter, or occupier is dispensed with. The third amendment is in relation to the industrial.
The layout plan.
Industrial.
Please.
Is in relation to layout plan
It's low.
for residential, commercial, and industrial premises, which in which the requirement of approval of layout plan by the competent authority is omitted. Full stop. Learned advocate paragraph, Miss so and so petitioner submitted that the effect of these amendments are drastic in nature, in as much as the electricity connection could be made available to the premises which does not have the approved plan, which may not have the occupancy certificate, And and in respect of which even the layout plan is not sanctioned by the competent authority. Full stop. The submission could be prima facie countenanced in as much as if the electricity connection is granted in such casual fashion, it may give rise to several evils and irregularities, which may have cascading effect. Full stop. It is to be deprecated that the writ petition was filed in the year 2022, and the notice was issued. Any other orders passed or any notices?
Notice is issued, my lord. After
Notice was issued as back on 7/11/22. Full stop. Till date, the respondent has not taken care of filing any reply. Full stop. In that view, there shall be notices to interim relief to the respondents returnable on September 12th. Before the next date, affidavit in reply, if any, will be filed, in absence of which the court will proceed to consider the subject matter in accordance with law to pass the orders in accordance with law. Thursday. Alright. Which date is kept? 18th,
Please.
12th.
It's
12th to be listed at 2:30.
May one submission, my lord. Serial number 64, my lords, matter pertains to unauthorized construction which is putting upon the forest land is concerned, my lord. A sought for further consideration of interval. Let me short date, my lord.
19th September.
My lords. Early dates, my lord. Early dates, my lord. Morning also I more mentioned the matter. Will lordship has advised to when the matter reaches, you please mention it, my lord. Pertains to unauthorized construction in the forest land is one. Film set has been going on, my lord.
19th September.
Lords, kindly consider, my lord.
Consider.
At least 2 weeks, my lord. 2 weeks, my lord. Kindly, my lord.
2 weeks.
2 weeks.
Further.
No, my lord. Earlier, my lord. Kindly, my lord. Consider kindly.
Not possible. So many matters.
My lord, serial 45.
Yes.
My lord, a short date may be given now.
Which one?
5 dates. So 45, my lords, a matter of
Okay.
importance relating to child helmets, which have made compulsory by the central government, my lords. 5 dates they have taken time to file the objection. Still date it has not been filed, my lords.
18th
Transport Department.
23 up with 18 September.
18 September. Grateful.
Yes.
74, serial number 74.
74.
Trying to pension.
Pardon? Yes.
Trying to pension.
Pension. 74. You are for respondent. It is the office of this.
Yes.
Furnishing of office of. Delay is also there. Office objections will be complied with within 2 weeks to be listed on 12th September.
Process people. Process party. Or after
74 ಅಲ್ಲಿ R1 ಗೆ ಪ್ರೋಸೆಸ್ ಕೇಳಿದ್ದಾರೆ. R1 14%. R1 14%. ಅವರೇ ಅಪಿಯರ್ ಆಗುವಾಗ R1 ಗೆ ಆರ್ಡರ್ ನೋಡ್ಬೇಕು, ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡು ಮಾಡಿ. 5 ಏನು ಡೇಟ್ ಕೊಡಿ, ಎಲ್ಲ ಡೇಟ್ ಬರ್ತದೆ. ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ಗಿವನ್. ಎಲ್ಲ ಡೇಟ್ ಹೋಗುತ್ತೆ ಸರ್, ಎಲ್ಲ ಮ್ಯಾಟರ್ ಡೇಟ್ ವಿಲ್ ಬಿ ಗಿವನ್, ಆಲ್ ಮ್ಯಾಟರ್ಸ್. ಎಲ್ಲ ಡೇಟ್ ಮ್ಯಾಟರ್ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ.
What is this? You're sleeping like that in the court.
I never.